Matters
Yes.
pertaining to principal seat, item number 1.
Wait, please, my lord.
Yes.
Yeah, my lords, if lordships recall, my lords, this matter comes up pursuant to a lordship's order of 26th March 2026, my lords,
Yes.
when your lordships had fixed this matter on the 5th of May. If your lordships have the order of 26th March, my lords,
Yes. Yes.
this, if your lordships recall, my lord, is a contempt petition.
Lord, I have a prayer, my lord, before my learned senior starts, my lord. My lord,
Yes.
Lordship, I prefer little accommodation today, my lord. My senior has some difficulty today, my lord. Kindly accommodate me with a short accommodation, my lord.
My lords, with the accommodation, I have no problem, my lord. That's my friends if he's in a difficulty. But my issue is this, my lords. Your lordships, if lordships have the order of 18 February 2026, my lord,
Yes. Yes.
your lordships directed, my lords, on 18 February, if your lordships have the order,
Yes. Yes.
that the petitioner herein, my lord, your lordship saw, my lord, the defenses which they put up, my lord, including an order which they sought to place before your lordships, my lords, of 11 July, which,
Yes.
according to their own case now, was never served, was never published,
Yes.
and not only that, my lords, they are also saying that nobody took steps even to serve the copy. Now, my lords, your
Yes.
lordships on 18th February order, if your lordships have this, my lords, my friend can take his time, my lord, that's not an issue, but just have 18th February order, my lord.
Yes.
Your lordships passed a detailed order, and if your lordships come, my lords, straight, my lords, to para 18, my lords, paragraph 18.
Yes.
Therefore, this court, in order to ensure that there is no continuance of the disobedience of the directions of this court, so as to uphold the majesty of this court, is inclined to hold that the respondents are required to first show that they have purged of their contempt, and therefore, as per the notification dated 11/7/2025, produced before this court, is relatable to the discharge order of 21/119 that had already been set aside by the common judgment and order of 28 June 2025. The court is inclined to pass an interim orders in terms of prayer 3 of the contempt petition, directing the respondents contemners to permit the petitioner to join her service without prejudice to the defenses which may be available to the respondents in this contempt petition, which shall be done within a period of 30 days from the date of this order. We further clarify that the interim order has been passed by taking into consideration, please mark, my lords, that as the current discharge order, by notification dated 11/7/25, produced before this court is in substitution of the discharge orders dated 21/119, which have already been set aside as clearly stated in paragraph 141 of the judgment and order dated 26/2025. Therefore, the said modified discharge order, read with the corrigendum of 21/7/25, would not come in the way of this court to issue such interim directions as may be required, so as to compel compliance of the orders under contempt. As the order is passed in the presence of the learned senior instructing counsel for the respondents, the order is deemed to be in notice of the respondents. Nonetheless, please mark, in addition to the deemed notice of respondents of this order, the petitioner shall produce a certified copy of this order to the respondent number 2, which would constitute due notice upon all the respondents. In the meantime, as the personal appearance of the respondents has not been dispensed with, the respondents shall file the affidavit by the next date of listing, failing which the court would have no option but to insist on the personal appearance of the respondents. Personal appearance of the respondents is dispensed with till the next date of hearing, that is 26/3. Now, your lordships now have the 26th March order, my lords. Detailed order, your lordships, my lords, directed that the petitioner should be allowed to join the service, gave them 30 days time. Now, please have the 26th March order, my lords. My lords have?
Yes.
I will crave your lordship's leave to read from paragraph 1. The learned senior counsel
Come
for
to the operative part. Come
Yes,
to
my
the
lords.
operative part because we are hard press of time here.
I understand, my lord. Please come, my lords, to paragraph 6 also, my lords, because your lordships indicated
Yes.
paragraph 6 Having heard both sides, though the learned senior counsel for the petitioner is prayed for further directions in continuation or order dated 18/2/26, but the court is of the view that as the respondents have taken a plea that there was no willful and deliberate violation or disobedience to the judgment and order dated 20th June 25 passed by the court, and then whatever action has been taken was in strict compliance of subparagraph 7 of para 140 of the said judgment, the court proposes to allow the learned counsel for the respondents to conclude his submissions before passing any further orders. Please mark the next sentence. However, in this regard, it would be proper and appropriate to clarify that the order dated 18 February 2026 passed by this court has not lost its force. So your lordships reiterated the 18 February order. Now please come to the directions your lordships passed. Paragraph 9.
Yes.
A. The court finds force in the submission made by the learned counsel for the petitioner that when the notification is not addressed to or marked to the petitioner, and when she is not the intended recipient, it would be too much for the high officials of the Transport Department and the Personnel Department of Government of Assam to expect that a peon to whom assignment is given to serve the said notification dated 11/7/2006 would even think of handing it over to the petitioner to whom the said notification has not even been marked. B. Surprisingly, when most of the files produced before this court are e-files, this particular notification, please mark my lord, dated 11/7/25 does not show that the said order is part of the e-file. C. After the petitioner has approached the court seeking enforcement of the judgment and order of 20th June by filing this contempt, the sudden production, please mark my lords, of the termination order dated 11/7/25 for the first time on 18/2/26 in course of this contempt proceedings can create a reasonable apprehension in the mind of the petitioner of an imminent arrest so as to frustrate the petitioner to pursue the contempt proceedings and to perhaps cover up the lapse on the part of the author of the said notification to either address and or mark the said notification to the petitioner. Accordingly, the court is of the considered opinion that this is an exceptional and appropriate case to invoke the court's inherent jurisdiction under Article 215 of the Constitution, which has been held to be an independent jurisdiction of original nature as decided by the Supreme Court. 10. Accordingly, in the light of the discussion, state respondents, including the CID, are directed to refrain from arresting the petitioner in connection with the FIR on so-and-so carried out so-and-so, shall not take any coercive steps. And then your lordships, my lords, fixed it on 5th of May.
Yes.
So all I am saying, my lords, is that the 18 February order is still operating, my lords. They should allow me to join without prejudice. Your lordships have said, without prejudice to your rights which you are entitled to take in the contempt petition. Today we are, my lords, even in the month of June. Almost, my lords, 4 months are going to expire. They are sitting on this order, my lords. It does not augur well, my lords. It doesn't reflect well. They should allow me to join. This order they have not challenged, my lords.
What is this interlocutory application for?
Yes, my lord.
What is the interlocutory application for?
No, my lord, there is no interlocutory application. This was for listing of the
Yes,
matter
it's-
because your lordships had fixed
No.
it on 5th May. Thereafter, the bench was not able.
Application is there. There's one IA Civil 996. You have not served, Mr. Nath, you have not served copy to Mr. Chaudhary.
Yeah.
No, my lord, this
Mr. Nath?
interlocutory, my lord, this interlocutory application was to place on
Lordship.
record, my lord, the affidavit in opposition. If your lordships have that, my lord.
Respondent seeking
Seeking, my
Yes,
lord,
vacating of the order dated 18 to
18.
Mr. Nath.
18 to,
Yes.
yes, my lord, 18 to 26 we have filed.
You have not served it to Mr. Chaudhary?
No, no, my lord, without serving copy, possibly filing is not possible.
No, because it is not here. The memo does not show that any notice has been served to the,
No, your lordships have also not
I'll-
issued notice.
I'll check, my lord, I'll check, my lord.
no, because then we can't take it. Oh, yes, somebody has signed it. Mr. Chaudhary, on behalf of
Yes, my lord.
Advocate Barnali Chaudhary, somebody has accepted it on 19.
But your lordships have yet to issue notice on that application, my lord.
We have filed
No,
on
but
19th of March.
Have you received it? 19th of March, yes. You have received it, that means.
19th of March, yes.
Somebody has received it, Mr. Chaudhary, on behalf of.
Very well, my lord. I'm not joining issue on that, my lord.
Barnali. Uh-huh.
I'm not joining issue on that, my lord. My friend must have served it, my
Yes,
lord.
my lord, copy they have, my lord.
That's,
Okay,
I'm told, my
yes,
lord,
yes.
for vacation of the order. But notice has yet not been issued, my lord, after a detailed hearing on 26th March. Your lordships have taken up the main matter.
Okay, Mr. Nath and Mr. Chaudhary,
Yes.
although the bench would not be available together, but we'll take it up on Tuesday then. It will be through video conferencing because my esteemed sister would be here and I would be in the principal seat.
Yes, my lord.
So it will be through video conferencing.
Very well.
My lord, Tuesday, it's 16th of June, my lord.
Ah, yes.
My lord, can it be on 18th, my lord? On Thursday, my lord.
Sorry. Okay, 18 then.
Lordship.
But this is. Since you're praying for adjournment, we are not saying anything, but
Lordship.
things are not
I'm
in
praying.
an appropriate way. It's
Lordship,
not
my
being
record.
did with an appropriate way.
Lordship.
May I say something, my lords?
Yes.
My lords, I want to say something, my lords, before your lordships pass the order, my lords. Not my lords as a lawyer representing a party, my lords, but an officer of the court. My lord, this is not done, my lords. They should. What I'm saying is, my lord, let them allow me to join. The lordships will hear the matter on returnable date and decide, my lord, this way or the other. Let them show, my lords, that they have purged themselves of the contempt. They can't, my lords, defy
Yeah,
an order of the
understand.
court. I understand.
We,
my
we
lords,
understand. That's why we.
very concerning, my lords. It's very concerning.
You are right.
Hmm.
But still, when we are considering a prayer for adjournment,
Hmm.
then to pass orders would again be complicating things.
At least we'll see their bona fides, my lords. Let them. They have to comply with. They have no option.
You are right. We don't say that we are not questioning your statement, but still,
I understand that, my lords. I will leave it to your lordships. My friends would advise, my lords. My friend, my lords, in cases we
it's
at
okay.
times.
We don't make any comment right now when we are considering a prayer for adjournment.
Very well.
We reserve.
I'll leave it to your lordship.
It-
Yes.
it-
Well,
it- Somebody
Only-
may think that the courts have disclosing their minds.
No, it's okay, my
So
lords.
it
I'll
is
leave it to your lordship.
any orders passed would be premeditated orders.
I'll leave it
We
to your
don't
lordship.
want that feeling to go.
Very well. Well, all I'm requesting is, my lords, the orders of 18th February and 26th February may be extended
Yes.
till the next date.
Yes.
I'm grateful.
Heard Mr. A. Chaudhary, Learned Senior Counsel, assisted by whose name should I record?
Meera Bora.
Meera Bora, Learned Counsel for the petitioner. Also heard. You say next para. Mr. D. Nath, Learned Senior Government Advocate, prays for an adjournment as the senior counsel for the respondents could not join the matter today. Full stop. Next para. The Learned Senior Counsel for the petitioner has submitted that till date, the respondent authorities have not purged of their contempt, and they are still not allowing the respondent, the petitioner, to join her post and to resume duties. So accordingly, he prays that in the event the court is inclined to allow the adjournment, the order dated 18/2/2026 and 26/3/2026 be extended till the next date of listing. Considering the prayer for adjournment made, the matter is reluctantly allowed. The matter is reluctantly adjourned. Next para. List the matter on 18/6/2026. Next para. And next order will be in this IA 966. Just add here that Mr. Chaudhary joins, Mr. Chaudhary and Mr. Dipankar Nath joins through video conferencing mode. This 966, you say, heard Mr. D. Nath, Learned Senior Government Advocate for the. Oh no, you will be appearing here as not as Senior Government Advocate, but as counsel, Learned Counsel for the applicants. And in the contempt case, he will be counsel for the respondents, not Senior Government Advocate. Also heard Mr. A. Chaudhary, Learned Senior Counsel assisted by Meera Bora, Learned counsel for the respondents through video conferencing mode. Next paragraph. This interlocutory application has been filed for vacating of the order dated 18/2/2026. First off, issue notice on this application, which is made returnable on 18/6/2026. Next, accordingly, accordingly, liberty is granted to the respondent to file affidavit in opposition, if so desired, at least 1 day prior to the next date of listing, by serving copy to the other side, list on 18/6/2026. Actually, here, in the main case, you say that we have said interim order 18 and 19/3 stands extended to the next date of listing. Oh, sorry, 26/3/2026 stands extended to the next date of listing. Okay.
Very grateful, my lords. But just one thing, my lords, I forgot to mention, my lords. My friend, Mr. Marto Kato, my lords, is assisting me from Itanagar, my lords. He's been kind enough, my lords. I requested him.
Okay, just record his name, Mr. Matugato.
I'm very grateful.
Yes, next. Any mentions?
Yeah, my lord.
Yes.
Well, item number 1718, my lord. I mean, lost of my paper book, my lord. Second set of paper book. I've requested the registry, my lord. So 1718, my lord. I'm for a big team, my lord. I've taken consent of the appellants, my lord. Council for the appellants. Can it be listed after vacation, my lord?
Okay, both sides are represented. Mr. B, on the prayer made by Mr. B. Vishal and counsel for the
Victim, my lord.
respondent number 2. Within bracket victim, the matter stands adjourned today. This is 2023 matter. Give a date after vacation. List.
21 July.
Okay. Yes.
My lord. Obliged, my lord.
I wish to mention item number 19 on behalf of PP Medi for the appellant
19. 19 and 20.
19.
You have been taken consent of the other side.
Yes, Lordship.
Okay.
And Lordship, matter may be listed on 18th of this week.
Okay. Both sides are represented on the prayer made by land counsel for the appellant. Matter stands adjourned today. List again on 18/6/2026. Okay.
May it please, Lordship.
Yes.
Lordship, item number 21.
Yes.
Lordship, here I am the legal aid counsel.
Yes.
I've just received the TCR only few days back only. Lordship, that's why I need some time to prepare. This is life imprisonment matter.
Okay. Okay, you have informed Ms. Ginny.
Yes.
Okay, you're there. Okay.
She also knows sometime.
Both sides are represented. On the prayer made by Mr. Yubori, learned legal aid counsel for the appellant, the matter stands adjourned today. List on, give a date after vacation.
21 July.
Thinking
Deeply.
high level.
Well, fixing the date, just see that those dates are not having matters which higher number of matters, so that you would
Yes,
not be able
sure,
to take
sure,
it up.
sure, definitely.
Rationalize that, huh? Okay, yes.
Lordship, back to mention a pending criminal trial for listing, maybe listing today. Pending criminal trial, maybe listing today.
Of which item?
Unlisted matter.
Criminal appeal. Criminal appeal.
Yes, yeah.
Okay, get it listed.
Deeply obvious.
Yes.
My Lordship, I beg to mention item number 1. On behalf of T. Tapak, due to medical emergency, he could not appear today. And with the consent of others party, we have taken consent.
Okay. On the ground that both sides are represented, on the ground that the land counsel for the petitioner, appellant holding the brief, had to have some medical emergency and for which he could not appear today. Full stop. Matter stands adjourned today. List on.
After 2 weeks. After 2 weeks.
List after 2 weeks. Okay.
Marvelous.
Item number 2.
Your Lordship. Lordship, before my senior counsel starts his argument, Lordship, this morning I have filed one affidavit in opposition. If it is in the record, we can take up the hearing. Otherwise, we have to call a record, Lordship. I have some
slip.
documents to rely
It will
upon.
come. Give the acquisition slip, it will come. Yes.
Well, actually, I submitted most of my arguments. It is subject to, I can only reply after he makes his submissions. It's an appeal, and in an appeal, an affidavit in opposition is filed, my lord. Of course, my lord, it's up to your lordship's discretion. But normally, in appeal, my lord, there is no scope for filing any affidavit in
It
opposition.
is neither a bar.
That's why, my lord, I said it's subject to your lordship's acceptance.
It's okay. Once he is filed it, no problem in taking it up.
But he may start, my lord. I'll, in my rejoinder, I'll submit.
Okay. Yes.
Lordship, since since day one of the election process of this Arunachal Cricket Association, Lordship, we have been agitating, Lordship. Lordship, here we have to understand how the election process has to be carried out as per the bylaws of ARCA, Lordship. I have prepared one chronological sequence of the bylaws, how the election process has to be carried out. For easy comprehending that particular provisions of all those election process that has to be carried out. Now, in every stages of this election process, the election process has been compromised. That is my contention in the earlier writ petitions that is pending before the single bench. In fact, I have filed 3 writ petitions, Lordship. In all these 3 writ petitions, Lordship,
Yes.
I'm alleging that, Lordship. And more importantly, Lordship, since there was a stay from the single bench, Lordship, 2 writ petition that was filed. Since there was a stay of the election notification itself, they kept on functioning, Lordship. Then another writ petition has to be filed, Lordship. And then that function, that notification that they were issuing, that was also a state, Lordship. And thereafter also they kept functioning, Lordship. So we filed one contempt petitions, Lordship, that is also pending. Just I wanted to bring into the record of this Honorable Court, Lordship. Now, my first issue that I would like to raise before this Honorable Court is, since the contempt petition is pending before the single bench, can the petitioners here in the appellants, can they seek equitable rights, saying that the IA had to be heard, Lordship? That is my primary objection in regards to the appeal that has been filed by the appellant in this instant case, Lordship. That is my primary contention, Lordship, first contention that I am raising, Lordship.
Yes.
And regarding the election process that has been compromised, Lordship, since there has been the appellant, they had been raising certain issues regarding in regards to the maintainability of the case itself, Lordship. In the last occasion, last hearing, Lordship was very clearly making an observation saying that yes, this court has the jurisdiction, Lordship. Since the BCCI, since this Arunachal Cricket Association is affiliated to the BCCI, they are very much amenable under Article 226, Lordship. I have several judgments, Lordship, to
In the
place.
course of the court deliberations, we are the here at the bench. We may say so many things. Correct.
Correct.
But we don't form an opinion. You'll have to take it that all this, all such statements we make is to understand both of you well.
Correct.
Does not mean that, supposing I say in an election petition, okay, the person who is law should be hanged. Will that be the law? Will I be bound by that? So no, our statements made is only to understand, only to interact. You will see you this, I will tell you this. You take Evidence Act. Necessary or unnecessary? I'm still an old-fashioned man. I'm still in Evidence Act. New BNS. I'm still not been able to remember all the sections. Now come to 165. It will be 168 in the new book.
Lordship often refers to that.
Yes, it's. I feel some pride when I refer to this. You see, read 165 proviso.
Judges power to put questions or order productions. The judge may, in order to discover or to obtain proper proof of relevant facts, ask any questions he pleases in any form at any time of any witnesses or of the parties about any fact, relevant or irrelevant, and may order the production of any documents.
So the court question can be relevant, can be irrelevant. Correct?
Agreed, Lordship.
Even if it is irrelevant, we have the authority to ask questions. But surprisingly, in no law, you will find that the lawyer has got that leverage of making some submission which is irrelevant.
Lordship, I was trying to make an observation saying that Lordship's observations on the questions that I was put before this honorable court, it's aligning the judgment that has been passed in Supreme Court, Lordship, by the FX court. That I wanted to submit, Lordship. Lordship is aware, Lordship, after all those judgments, Lordship, this IPL makes fixing on, Lordship. In all those mismanagement of all those administration of BCCI, Lordship, the FX court had to intervene and they formed one committee, that is LODA committee, Lordship. They came up with certain guidelines, Lordship, that was incorporated in several judgments of the Supreme Court, Lordship, whereby categorically they have stated that those guidelines has to be mandatorily be implemented in the BCCI bylaws as well as the affiliated bodies of the BCCI, Lordship. Now the contention of the petition appellant here in Lordship, that they are a private body, their contention is that they say that they are the private body, Lordship. That is not at all, that does not hold any water, Lordship. Why? Because, Lordship, if we see the bylaws of the ARCA itself, in the first page itself, it goes to say that the ARCA is affiliated to BCCI. Now, when they are affiliated to BCCI, they are governed by the several judgments that has been passed in the apex body, apex court. They cannot run away. They cannot blow hot and cold. Once one in the constitution is there, they say that they are affiliated to BCCI, and they cannot now say that they are a private body, and since they are registered under the society registration of Arunachal Pradesh, they are not amenable or they are not being governed by those guidelines or the statutory rules that has been directed by the apex court. First page दिखा दो तुम्हें. Since I'll be placing my argument on the basis of Writ Appeal 36, Lordship may kindly take up Writ Appeal 36. 36. This is the Writ Appeal in which they have challenged the order passed in WPC 97 of 2026, wherein they have in fact filed one IA 110 of 2026, Lordship. I'll be relying on this particular paper books to make my submission and arguments, Lordship.
Yes.
Lordship may kindly take up page 88, Lordship. Lordship will kindly see the Constitution of ARCA, Arunachal Cricket Association, established in 1997. Registration, Lordship will find. Now down below, after the logo, Lordship will see. Lordship, I got page 88, Lordship.
Yes.
It clearly goes to show that it is affiliated to BCCI, Lordship. Affiliated under Board of Control for Cricket in India.
Yes.
Next page, page 91 also, Lordship. Clause number 4, subclause 6.
Yes, please proceed.
Page 91, Lordship.
Yes, yes. Please continue.
Clause 4, subclause 6. It clearly says to hold and maintain the laws of cricket and the rules and regulation of the Board of Control for Cricket in India. So, in their aims and objectives of the association itself, they clearly goes to say that they are governed by the BCCI's rules and regulations. Now, Lordship, I have the rules and regulations of the BCCI also, Lordship. Now, I have gone through the rules and regulations of the BCCI. Now, all those rules and regulations of the BCCI has been in total been implemented in this bylaws, Lordship. All of the rules and regulations, most of the rules and regulations, Lordship. And then those guidelines, those mandatory bylaws, which was recommended by LODA committee, has been incorporated in these bylaws, Lordship. Now, they cannot run away, they cannot violate what is there in the bylaws, Lordship. Now, in the whole election process, in the 3 writ petitions, Lordship, we have alleged that there was a violation of all those bylaws under this ARCA rules, Lordship, rules and regulations.
Which particular rules, according to you, were violated?
Lordship, I'm coming to that. Lordship, may kindly take up this particular piece of paper. This just to show that, just to assist this court, the important clauses of this particular rules and regulations or rules in regards to the election process. Lordship, rest we will not be dealing, only in regards to the election process we will be dealing. Lordship. Lordship, may kindly come to Rule 36 subclause 1. Lordship will find that page 116, Lordship, 116.
Yes.
116, Lordship, Rules 36, Lordship. The electoral officer. Now, once as per these rules, Lordship, once the tenure is over, Lordship, normally as per these rules and regulations of ARCA, Lordship, the tenure of the FX Council is 3 years, Lordship. Now, Lordship, I have, in my writ petitions, Lordship, I have annexed the incumbency of those FX councils who were governing at that point of time. Now, their tenure was over by October 2025, Lordship. Now, since they were not conducting the elections, Lordship, now we, the affiliated bodies of Arunachal Cricket Association, most of the president of district cricket associations, they agitated and said that the free and fair election has to be convened and the new FX council has to come as per the election bylaws. So upon our protest, now they say that they have appointed an electoral officer. But in the initial writ petitions that I filed, Lordship, initial writ petitions, post writ petition that I filed, there were certain notifications that they have brought in, but those notifications were not from the electoral officer. That was my allegation in the initial stage, Lordship. Not from the electoral officer, but from the honorary secretary, who was the member of the FX Council, Lordship. Now, as per this section, Rule 36, Lordship, I am reading that Rule 36, Lordship. At least 4 weeks prior to annual general meeting at which an election is to be held, the FX Council shall appoint an electoral officer who shall be a former central or state election commissioner. Sub Rule 2, Lordship. The electoral officer shall oversees, this is important, Lordship, oversees and supervise the entire election process, including scrutiny of the electoral rolls, scrutiny of the electoral rolls for the FX Council, which shall include all the nominations, candidatures, being subject to his scrutiny in accordance with the rules. In case of any dispute, this is also important, Lordship. In case of any disputes or objection as to candidacy, disqualification, eligibility to vote, or the admission or rejection of a vote in the election to the FX Council or any of the committee, subcommittees, the electoral officer shall decide the same and such decision shall be final and conclusive. Now, in the initial, when the notification was notified in the website, in the WhatsApp group of the District Cricket Association, that notification was coming from the honorary secretary. Now, in that initial writ petitions, we have agitated, saying that this is a violation of Rule 36. There has to be an electoral officer who has to supervise, who has to come up with the electoral roll, who has to prepare the electoral roll. And all those were not coming forth. So we agitated in the initial first writ petition, saying that this particular Rules 36 had been violated. So accordingly, that particular order was passed by this Honorable Court, subject to the outcome of the writ petitions. And apart from that, this Honorable Court also has categorically directed the FX Council of the ARCA, Arunachal Cricket Association, to conduct the election as per the law. When we put across all those arguments before the single bench, being convinced, that direction was accordingly passed. So after passing of that particular judgments, we approach before the concerned authority again, saying that at least that electoral officer has to be appointed. The name of the electoral officer was kept aloof from us since inception. Lordship, I'll just show some documents to show how the honorary secretary was acting like an electoral officer since inception of the election, whole electoral process, Lordship. Lordship, may kindly come to page 128, Lordship. Lordship, we have read Rule 36. It very categorically says that once the electoral officer is appointed by the FX Council, their roles ends there. Now, the role of the electoral officer has to come and he has to play the role, Lordship. In place of him, Lordship, my contention in the second round of the writ petition also, Lordship. This is one of my ground, Lordship, saying that those all notifications were coming from the honorary secretary, not from the electoral officer. These are all some of the documents which clearly goes to show that honorary secretary was acting on behalf of the electoral officer. The whole electoral process was compromised from the inception, Lordship. Since inception, page 128, Lordship. Lordship will see NB Vivek, Lordship. He is the honorary secretary, Lordship. This is the WhatsApp communications in the WhatsApp group of, in the top, Lordship will see District CA, Arka. This is a WhatsApp group created for District Cricket Association, Lordship, along with the FX Council, Lordship.
150?
128, Lordship.
28.
128.
Yes.
This is the WhatsApp group created to communicate certain official communication with the District Cricket Association, along with the FX Council of Arka. So, as per this, Lordship will see NBM Vivek, Lordship. He's the honorary secretary whose tenure was over. He was the acting honorary secretary at that point of time. After the appointment of the electoral officer, his roles ends there, Lordship. He was still acting, Lordship. This notification, Lordship will see.
Given those dates, when the electoral officer was appointed, when this termination takes place.
They have the applicant, in fact, they have come up with their all those notifications subsequently in their IA. They say that all those notifications were already there, but it was never notified. It was never notified to us. Now we say that those all documents were backdated documents. That is our one of the contention, because in the initial inception, if that notifications were in existence, they could have notified that notifications. Now in the IA, they have come up with all those notifications, saying that electoral officer was appointed prior to 4 weeks, and all those notifications were issued by the electoral officer. But in the initial inception, where we were protesting, when all those notifications were coming, that the notification of electoral officer was not at all in the existence, Lordship. Now, in the second round of writ petitions, one of our contentions was, Lordship, the electoral officer was brought to the state for only 1 day. Other days, he was not at all here, Lordship. Since we were protesting from the day one, Lordship, the electoral officer was kept aloof from us, Lordship. We were asking the name of the electoral officer, no notification, nothing as such, Lordship, published from the FX Council, Lordship. Lordship, may kindly come to page. This is the notification, Lordship. 131, Lordship. Lordship will see this notification is coming forth from the honorary secretary, Lordship, down below, Lordship. Signature and everything is from the honorary secretary.
100?
This notification also ought to have been from the electoral officer, Lordship. 131, Lordship. The Apex Council of Arunachal Cricket Association, ARCA, is pleased to notify the AGM election of ARCA to be conducted on 24th February 2026 at Hotel Donipolo International Y in Itanagar.
Page 128 WhatsApp, what is the date of this WhatsApp?
I am told that it's the same date of 7/2/2026, Lordship. 7/2/2026. This particular the notification that I am referring to in page 131. That notification was uploaded in this particular WhatsApp group, Lordship. After seeing these notifications, Lordship, we agitated, Lordship, saying that this notification should be coming forth from the electoral officer, not from the honorary secretary. If you have appointed an electoral officer, this notification has to come from the electoral officer, not from the honorary secretary. The whole election process has to be carried out by the electoral officer, not by the electoral honorary secretary. Lordship may come to next page, Lordship, 132, Lordship. कौन सा पेज इसमें देखो Lordship has the page 132, Lordship.
Yes, please continue.
Oh, Lordship. Well, this documents will clearly goes to show, Lordship, how the whole election process was compromised. This documents, Lordship, this page 132 documents, Lordship, meeting resolution, will clearly speaks that how the whole election process was compromised. I have been instructed, Lordship, that this particular meeting was conducted in the house of the honorary secretary, Lordship, private residence. Lordship, I'm just reading out that meeting resolution, Lordship. A meeting of the president and honorary secretaries of the affiliated district cricket association with the office bearers of the Arunachal Cricket Association was held on 11 February 2026 at Mitpur, Toimuk. The meeting was convened to discuss the election of new office bearers of ARCA, for which the election is scheduled to be held on 24/2/2026. The members present had a detailed and threadbare discussion on the matter, and the following points were resolved. That the new office bearers, this is important, Lordship, the new office bearers of the ARCA shall be selected by the outgoing ARCA team. Now, I'll come to those provisions, rules and regulations, Lordship. Who are the electoral, who are the voters, Lordship? The ARCA team, they cannot be a voters, Lordship. The affiliated body of ARCA, they are the voters, Lordship. Either he will be the president, or in his absence, the secretary will be, his name will be there in the voter list, Lordship. Now, in a subsequent argument, Lordship, I'll also demonstrate how the voter list was also compromised, Lordship. Now, through these resolutions, they are trying to select themselves, Lordship. Instead of going for the election process, proper election process, fair election process, they are compromising. Through these resolutions, they are compromising the whole election process itself, Lordship. And second, Lordship, second resolution that was adopted, Lordship. The members unanimously agreed that Sri Nabam Vivek shall continue as the president of ARCA. How can he, Lordship? He was serving as the honorary secretary. Now they say that he will continue, Lordship. In the second round of writ petition, Lordship, and in fact in the first round of writ petition also, Lordship, since we came to know that he would be contesting as one of the presidential candidate of ARCA, our primary contest in the initial inception of this election process was that as per ARCA bylaws, Lordship, as per governing FX course decisions, and as per the governing rules of BCCI, Lordship, it is mandatory that a FX body council can at the most be in the office for 6 years, Lordship. After completion of 6 years, he has to mandatorily go for cooling off, Lordship. And at the most, he can be in the office for 9 years. But this after completion of 6 years, he has to go for cooling off, Lordship. Now, this Nabam Vivek, who is the president, who was elected president, so to say, who was the elected president, was one of the candidates in the election process. He has already completed the 6 years tenure. Now, through this resolution, they are trying to bring him by bending all those bylaws, Lordship. Lordship, I'll try to place those rules and regulations whereby it talks about the cooling off, Lordship. One second.
Yes. Please be fast.
Lordship, yes. Rules 12, Lordship.
In your language, we have a-
Page 96.
in your language, we don't have a cooling period. This matter we'll have to take up another matter.
Lordship, I'll try to be fast, Lordship. Page 96, FX Council, Lordship. I'll just refer to 12E, next page, Lordship, page 97. We'll read
97
E.
of
Read Able 36, Lordship.
writ appeal.
36. I'll be relying upon all those documents that has been
Okay.
annexed in the Read Appeal 36 only.
Yes.
90s.
97, page 97. 12E, Rule 12, Subrule E. Each of the elected members of the EPIC Council shall have a term of 3 years in office, subject to a maximum of 3 terms. 3 years, 3 years, 3 terms, 9 years. On the FX Council, a member of FX Council who has held any post for 2 consecutive terms, either in the association or BCCI. In this particular case, he was in the Arunachal Cricket Association for more than 6 years, Lordship. I have annexed those documents to show those incumbency board to show that he was in the office for more than 6 years, Lordship. Shall not be eligible to contest any further election without completing a cooling off period of 3 years. During the cooling off period, such a member of FX Council shall not be a member of the governing council or of any committee, subcommittee whatsoever of the BCCI or of the association. The expression members of FX Council should not be permitted to be circumvented by being a member of any other committee, subcommittee, or of the governing council in BCCI or association as the case may be. Now, this is a mandatory provision, Lordship, whereby it says that after completion of 6 years, he has to mandatorily go for cooling off, Lordship. That was not complied, Lordship. Now, through these resolutions, they are trying to circumvent this particular bylaws, Lordship. So in this particular meeting also, I've been instructed that he was the chairman, but as per bylaws, if such resolutions are drawn, the president should be the chairman, Lordship. He convened the chairman, he himself is taking out this kind of resolution, and he is trying to project himself, in spite of knowing the fact that he has to mandatorily go for cooling off, Lordship. Same day, Lordship, page 134, Lordship. One 134, Lordship, has page number 134. Another notifications, Lordship, from the Honorary Secretary again, Lordship. The affiliated District Cricket Association are directed to submit the name of a representative authorized to attend the AGM scheduled for 24th February 2026. Their name should be given on or before 14th February 2026 to the undersigned. Again, the election process being compromised, Lordship. It has to come from the electoral officer, Lordship, seeking the voter list of the electoral roll. While preparing the electoral roll, Lordship, definitely they will seek the voter list from the district affiliated bodies, Lordship. We are the affiliated bodies, Lordship, who are before this honorable court, Lordship. Now that has to come forth from the electoral officer, but from this, this notification is coming from the Honorary Secretary, Lordship. So 140, Lordship, page 140. This was for our representation before the Honorary Secretary, raising several objections, the way the election process was being compromised. The representation we submitted before the Honorary Secretary by all the petitioners in all those 3 writ petitions, Lordship.
Yes.
In this representations, I have raised all those issues, Lordship. I'll not read those. Lordship, since I was making submissions in regards to the voter list, Lordship, now who can be, whose name can be in the voter list, Lordship? Lordship, may kindly come to Rule 32, page 112, Lordship. Rule 32 says representation in annual general meeting and special general meeting and voting. Each affiliated member and each former international player member shall have the right to take part in a deliberation at an annual and special general meeting that shall be have the power to vote and shall be eligible for election to any office of the association subject to the following. Unaffiliated, we are the affiliated members, Lordship. We are the president of district cricket associations. So we are the affiliated members, Lordship. An affiliated member must not have failed to pay any dues to, that is not under dispute, Lordship, on or before 30th June. In case of an affiliated member, while preparing that voter list, in case of an affiliated member, the elected president will be eligible to vote. And in his her absence, the elected honorary secretary will be allowed to do so. The first priority would be given to the president. Then thereafter, Lordship, secretary, Lordship. However, the elected honorary or his equivalent will be given priority over the nominated or ex officio president of a affiliated member in the matter of voting. Proposal raised that the annual general and an special shall be decided by majority of votes. Voting shall be by secret ballots. That was also violated, Lordship. One of my contention would be, Lordship. Chairman shall have a casting vote, Lordship. Since the election process has to be conducted in one of the AGM, final AGM that has to be called by the president, that also was not done in this case, Lordship. They have simply declared the result only, no AGM as such. Now here, chairman also has the voting right, Lordship. When there is a tie, Lordship, in that scenario, when secret ballot would be there and after counting the vote, if there is a tie, then the chairman will have the right to vote, Lordship. That also was not done in this case, Lordship. No AGM as such. AGM, of course, was called, but that AGM as such, no resolutions as on today, Lordship. No papers to show that the AGM was conducted. Only that result notification is being published, Lordship. No AGM, nothing resolutions that was adopted on that day, Lordship. Since no AGM was conducted, Lordship, no chairman was not there, Lordship. That particular disclose also was compromised. Then the secret ballots, that resolution that I have shown, Lordship. By the resolution only, they have given the list for one day that the electoral officers were brought in, and that list that was given by the honorary secretary, the electoral officer has put his initial. That is our contention, Lordship. The whole election process was compromised. Lordship, that we have the video footage also on for the day, Lordship, when that particular voting day was convened, Lordship. That day also we were not allowed to get inside the room, Lordship. The president. Now here in this, in all those three repetitions, Lordship, we in total 11 affiliated district cricket associations are affiliated to Arunachal Cricket Association. Out of 11 cricket association, Lordship, six of them were agitating, Lordship. All of the presidents of the cricket association were agitating, Lordship. Now, as per this voter list that was to be prepared, Lordship, mandatorily the first preference has to be given to the president. Thereafter, the secretary. Thereafter, upon authorization, only rest of the, in their absence, rest of the council member of the district association will have the right to be in the voter list. The provision is very clear, Lordship. Now, after our agitation, Lordship, in their IA, they have come up with the voter list, Lordship. Now we say that this voter list was after prepared documents, Lordship. Why all those things were compromised, Lordship? I'll just demonstrate, Lordship. I'll show that particular notification from the electoral officer, Lordship. Lordship may kindly come to page 240. This is a documents annexed in their IA in the single bench, whereby they are trying to project before this court, saying that the whole process was done as per the bylaws of ARCA. Page 240. Lordship, as I was submitting, Lordship, 11 affiliated district cricket association with the Arunachal Cricket Association, Lordship. Lordship will see that 11 name of the district cricket association. Now, Lordship may kindly see the name of the representatives in the right hand side of that column, Lordship. Serial number 1, Lordship may kindly see, Lordship. I've been instructed, say, Lordship, that this particular person, Mr. Song Tacho, he's not the president. He's the general secretary, Lordship. Lordship, as per the bylaws, first preference has to be the president. Now, our contention is that we wanted to submit our voter list, Lordship. That notifications also, all those were never notified to us. And then that notifications that they are placing before this honorable court, these are all afterthought, Lordship. When we are agitating before this honorable court, then only they have brought out with these all those documents, Lordship. Otherwise, if they had notified it, obviously, being the president of 6 district associations, we could have given our name and list. That name and list was never sought from us, Lordship, by the electoral officer, Lordship. Now, this list, I've been instructed that this list that has been furnished, these are all lists provided by the honorary secretary. So one of our major ground coming before this honorable court is that the electoral roll also has been compromised, Lordship. One of the ground, Lordship. Lordship, rest, Lordship, serial number 2, of course, he is the president. We are not disputing that, Lordship. Serial number 3 may be taken up, Lordship. He is the Navam Vivek, who is the who is one of the candidate and who is the serving honorary secretary, who has become functus officio, Lordship. His tenure is over by October 2025. Now he is placing himself as one of the voter list. But Lordship will kindly take up rule. There is a rule under the bylaws. Once you become the member of the FX Council, you cannot be in the voter list, Lordship. You cannot vote. But here his name is, he has put his name, Lordship. So now from this clearly, Lordship will see that this whole list is being prepared by him only, Lordship. So he is not allowed, he is prevented from putting his name as per the bylaws. How can he put his name, Lordship? And he is not a member of the Papumpara District Cricket Association, Lordship. I am not a member, Lordship. Papumpara Cricket Association president is one of the petitioners herein in the 3 writ petitions, Lordship. Secretary is different person, Lordship. President is different person. I'll just show that particular provision, rule 14,
Page list
240. Na? Also, we'll find it at page 99. I'll just highlight 2 relevant provisions of this rule 14. This talks about disqualification, Lordship. Lordship, initially I have argued that he has already completed 6 years tenure, Lordship. So on that ground, he is ought to go for compulsory cool-off period. But he did not. He contested, Lordship. So electoral officer ought to have disqualified his candidature then and there itself, Lordship. As per this rule 14, sub-rule F. Same provision that I have shown in the earlier rule, Lordship. 14F. It's just the copy paste of that particular provision. This is one of the ground that if he's not complying this particular provision, he can be disqualified. He is liable for disqualification, Lordship. So next page, 100, page number 100, Lordship. This is one of the ground for disqualification. So page 100, Lordship. This is one of the provisions that I wanted to show, Lordship. This is one of the ground also, Lordship. Dead depot, Lordship. 14 sub rule 2, page 100. Next page, Lordship. Notwithstanding anything contained elsewhere in these rules, a former president of the association shall not be entitled to be elected or nominated to the FX Council in any capacity except for a second and final term as president, subject to Rule 13 and 14 subclause 2 above. This is important, Lordship. No member of the FX Council, once elected, shall hold any office in a affiliated member. Now he is trying to project here in that particular electoral notification. He is neither a president nor a general secretary. By these particular provisions, once you become the FX Council of that particular association, you cannot be a member of district associations. Through this also, he is nowhere to be in the voter list, Lordship. But he has put his name there, Lordship. This clearly goes to show how the election process has been compromised, Lordship. And serial number 4, Lordship, we are coming back to 240, Lordship, page 240. We have seen that serial number 3. The whole voter list has been compromised, Lordship. That is my contention, Lordship. I just want to demonstrate how the voter list has been compromised. Now, serial number 4, Kabak Jun, he is not the president. I am told that he is the vice president. Page 240. He is the vice president. As per the rules, Lordship, vice president. Yes, yes. And serial number 5, we are not disputing, he is the president. Serial number 6 also, we are disputing, he is the secretary. First preference has to be the president, then secretary will have the right. 7 also, he is the secretary. Number 6 is the Mr. Roger Nabam Hina. I'm told that he is the secretary of that particular district association. Secretary. I'm saying that first preference has to be the president. Then the secretary comes in his absence. Secretary, 7 also secretary, 8 also secretary, 9 also secretary, and 10 is, he is neither a president nor a secretary nor a member of the district association. He's just a player. Not a famous player, but a player, cricket player. I'm told that he's a cricket player. But in that rule, he has to be an international player. Then only he can be in the voter list. But he is a player, of course. And 11, his name has been put Dosh Dashi. He is the president of, in fact, he is the president of Upper Subansiri District Association. But after finding all those irregularities, he walked out from that particular this thing, AGM meeting that was convened. He walked out, and he is one of the petitioner here in all those writ petitions, Lords. He is also agitating that the election process has to be as per the RK rules and bylaws, the rules and regulations. Lordship, may kindly come to page 244. This particular declaration of result that I have put into challenge in my second writ petitions that I filed in the single bench. Since all those voter list was compromised, Lordship, most of the persons whose names are in the voter list, Lordship will find their name in this result list, Lordship. Nabam Vivek, Kamei Anko, Roger Nabam Hina, Nipang Mulam, Song Tacho, Sering Benjor. Most of them. Most of the name whose names are in the voter list, their names are. Lordship, yes. And one more, Lordship, interesting facts that I just wanted to highlight, just to cover up their illegalities. They have committed one more illegalities, Lordship, that they have come up with amendment of the bylaws, Lordship. That they are prevented from doing it, Lordship, but they have done it, Lordship. They have, in fact, they have annexed that bylaw, Lordship. Lordship will see that bylaw at page 37. They say that this is the amended bylaw, page 37, Lordship. Uh, 202, Lordship. 201, 2N. 0. Double die. Lordship will see page 37 or 202. In there is an existing bylaw, Lordship. The bylaws that I have shown, Lordship. Now they say that they have come up with the amended bylaws, Lordship. Through these bylaws, certain rules were amended, Lordship. Most of them they have incorporated, but some of the most relevant provisions that has been amended, Lordship. One of the provision is, Lordship, the term of the office. It was 3 years. They have extended it to 4 years. Of course, they are not harping on those things, but how illegally they are doing it, Lordship. Now, Lordship will kindly see that their tenure was over by October 2025, Lordship. Once their tenure is over, Lordship, they ought to have convened a AGM and they ought to have gone for an election, Lordship. In spite of doing that, Lordship, they are doing this, Lordship. This amendment was brought on 23rd 12 2025. In this regard, my contention is, Lordship, in the earlier submissions, although I've been submitting before this honorable court, all those bylaws, Lordship, that has been incorporated and all those provisions, rules and regulations are being brought in by the several directions of the Honorable Supreme Court and several direction from the, in fact, from the BCCI, since we are the ARCA is the affiliated body. So, Lordship, may kindly come to page 121, Lordship. 120, Lordship, sorry, page 120. '44, down, Lordship, down below. Lordship. This particular rule, Lordship, talks about, Lordship, they cannot simply go for amendment. They have to take the leave of the Supreme Court, Lordship. This particular law also says, Lordship, they judgments of the Supreme Court, where it says that if you want to bring amendment into the bylaws of the association, Lordship, they have to take the leave of the Supreme Court, Lordship. This clause also speaks about that, Lordship. That also has been violated, Lordship. Yes, sir. I was on that particular ground showing that they have come up with another amendment of the bylaws, Lordship, that I have shown. In fact, they have annexed it in their IA. which is part of the record before His Honorable Court, Lordship. As per Rule 44, page 120, Lordship. Plus, amendment cannot be given effect to Lordship without the leave of the court, Lordship. So they, in every step, Lordship, they are circumventing the bylaws, Lordship, that I wanted to impress upon this Honorable Court, Lordship. Lordship, may kindly take note of that, Lordship, that particular point, Lordship, that I have raised. And two more documents to show, Lordship, how the documents were generated, Lordship. Lordship, may kindly come to page 237.
237.
Lordship.
Yes.
This is a notification, Lordship, of the entire election process that was to be carried out, notifying the dates, scrutiny dates, Lordship, submission of electoral rolls, everything, Lordship, which I have clearly demonstrated, Lordship, how all those processes were compromised. Now, my initial inception's argument was, Lordship, all those notifications was coming forth from the honorary secretary. Now, this notification ought to have come from the electoral officer. Now, Lordship will kindly see these documents, 237, down below, Lordship. The seal and stamp and signature is of the honorary secretary. Now, immediately, when we agitated before this honorable court, saying that this old notification was never notified, then they come up with another documents, Lordship, page 238. It is part of the IA. Now, what prompted him to come up with this notification and then by the electoral officer? Very doubtful, Lordship. 238, please immediate next page, Lordship. Now, this is from the electoral officer. Initially, it was from the honorary secretary, same notification, ditto. Nothing changed, nothing yet. When we agitated, they now want to demonstrate before this honorable court that it was notified by the electors. But initially, it was notified by the honorary secretary. Backdated, Lordship. Generated documents, Lordship, we are contending, Lordship. It seems from the initial argument, Lordship, one of my argument point was, Lordship, this electoral officer was with full responsibility, I am submitting, Lordship, that this electoral officer was brought in the state for only one day, Lordship. They ought to have been for the last 4 weeks, Lordship, before convening of the electoral process. He has to be here before 4 weeks. All notification has to come forth from him. But my instructions goes less, Lordship, that he came here only for one day. In fact, to show that he was here only for one day, Lordship. In fact, we have submitted on that very day when that election process was carried out, Lordship. Since we were not allowed to enter in the meeting also, Lordship, but anyhow, we went inside and we submitted one representation, Lordship. That is also part of the record, Lordship. There we have demonstrated every facts what was happening before, Lordship, before he came, Lordship. Lordship, kindly take up the reply that I filed, Lordship. Reply that I filed, Lordship, affidavit in opposition, page 389. Since we found him only for one day, so this representation was filed before him. Since day one, we were looking for him,
Page
Lordship.
number?
Page 389. Annexure 10. This is the joint application that we have filed. in the next page, 390, Lordship. In the middle, Lordship will see page 390, serial number 2. One of the ground we have agitated before the electoral officer, since we have seen him for only one day, so we have clearly mentioned regarding the concealment of electoral officer identity. Never ever disclosed to us, no notifications was ever served to us by his name. That all electoral lists which they bring now, that was never notified to us. Otherwise, we could have agitated before the electoral officer. But that opportunity or that notification was not in existence at that point of time. That right to agitate, scrutinized, or to complain in regards to our voter list that was published, that right was curtailed. So here we have clearly demonstrated before the electoral officer, raising all those issues. Lordship will see in page 3, next page, 391, the electoral officer has received it and no action, no disposal of the representations from its end. Now, bylaw says that in case of this kind of complaints, or in case of such complaint coming from the voter list or the affiliated bodies, the electoral officer is mandatorily, he has to dispose of the issues. It is well within his power that he has to dispose it of. Lordship, one of my another ground is
that provision.
That provision, Lordship, will
36(3).
36. Yes, 36(3). Correct.
116, page 116.
Thirty-three. 36(3).
Page 116.
That right also was curtailed, Lordship. In case of any dispute, objections as to the candidacy, disqualification, eligibility to vote, or the admission or rejection of vote in the election to the FX Council or any of the committee, subcommittee, the electoral officer shall decide the same, and such decision shall be final and conclusive. This particular right was also curtailed. No voter list it was never notified to us, Lordship. That list that they have shown, if it was notified, we could have agitated. Definitely we could have agitated. Why the secretary name has to be there? I am the president, Lordship. I will be there to vote, Lordship.
Yeah.
In 394, Lordship, page 394. This is also one of the documents goes to show that the whole election process was compromised. This is the, in fact, they say that it's a format for nomination paper notified by the honorary secretary himself, who is the candidate himself in the particular election process. Now I am told that this particular paper was also not served to us. We went to seek this particular nomination since some of the petitioners, they were intending candidates. They wanted to contest in the elections, but this nomination paper was never furnished to us. In fact, Lordship will see, this is coming forth from the honorary secretary, who himself was the candidate in that election process, wanted to be elected as the president. And this is not coming from the electoral officer. And it was never furnished to us. That is the instructions that I have got, Lordship. So that right also to contest in the election was also waived, curtailed by them, Lordship.
Okay,
So Lordship,
going on any case laws?
Lordship, I'll just sum up my argument, Lordship. Now here, Lordship, the entire process, Lordship, that I have demonstrated, the entire process was compromised. Electoral,
Don't repeat. You are, in fact, testing our patience.
Lordship,
Submit your case laws and end your.
Lordship.
We can't. keep
Lordship,
saying the thing again and again.
the BCCI, Lordship, judgments are there where ये वाला है, वो दूसरा है, same है, एक ही second, ये वाला ही है। ये तो कम है ना, मोटा है, वो आगे पीछे आगे पीछे। The relevant paragraph is 32, 33, 34, 35. Regarding the maintainability, Lordship. 32, 34, 32, 33, 34, 35. Pulling the grade. 32, 33, 34, and 35. Lordship, this paragraphs is in regards to maintainability of the petitions, whether it is amenable, Lordship. It clearly says that since the cricket associations, they are
Okay.
yes, public body, their function is can be said as public body, Lordship. So they will be amenable, Lordship.
Yes. Mr. Datta.
119 also, Lordship. Page 119. Regarding the proposed committee. Page 119 also. Relevant paragraph is 119 also. What? Then one more judgment, Lordship, of same BCCI versus Cricket Association of Bihar, Lordship. There were several judgments, Lordship, subsequent judgments. Page, paragraph 35. Lordship, this judgment of 2016 that we are relying, paragraph 35. Paragraph 35, we are relying for cooling off period, Lordship. It was in fact incorporated in the bylaws, Lordship, that was not followed. Similar kind of a situation in Jammu and Kashmir, Lordship, where the Honorable High Court has intervened and appointed an administrator. In fact, has directed the BCCI to look after the Jammu and Kashmir Cricket Association's affairs, Lordship.
क्या नाम है इसका citation क्या है?
City Cricket Club, Singer, बहुत है sir. So many litigations club up together and in one judgment they have passed.
Citation बोलते हैं ना इसका?
2021. 2021. SCC online.
Okay.
Lordship, the Jammu and Kashmir judgments, Lordship, in the writ petitions, since we have sought certain relief from the Honorable Court, saying that BCCI has to intervene and they have to appoint an administrator to look after the day-to-day affairs. Since I have filed one contempt petitions also against them, saying that they have willfully violated the orders of this Honorable Court. Since there was a stay from this Honorable Court, they keep on functioning. So we wanted, since all the election process was compromised, so Lordship, there has to be administrator appointed by this Honorable Court to look after the day-to-day affairs of the Arunachal Cricket Association. So this judgment of Jammu and Kashmir, similar situated facts. Paragraph is Lordship
The
4, 5,
appointment of
8,
administrator is
18.
not an issue
Complete.
in the appeal.
Complete.
No, I'm just indicating, my lord, that is not an issue in the
Let
appeal.
him complete. He is making an argument. Let him complete. You can demolish it when you make your reply. Paragraph.
Paragraph 4, 5, 8, 18, and 22, Lordship.
4, 5.
4, 5, 8, 18, 22. So we want, paragraph 22 is in regards to the direction of appointment of administrator, Lordship. In such cases, Lordship, how the court intervenes, and Lordship is aware about the Loda committee report and the subsequent judgments from the Supreme Court. They wanted to bring certain reformations in the cricket administrations. So why they intervened, Lordship. Now here also, Lordship, will see how the election of the Apex Council of ARCA has been hijacked by a single person, Lordship, who is the, in fact, appellant in this instant writ appeal, Lordship.
Yes, Mr. Datta.
My lord, my learned friend has practically argued the writ petition, although the appeal is with regard to the interim order. So, my lord, I need to be little elaborate, my lord, in my response. I have just prepared an index or run of events, my lord. If your lordship will kindly peruse this, my lord, it will be convenient, my lord. My lord, may I kindly see, I'll be as brief as possible, my lord, just to give a background of the litigation, my lord. First is the writ petition 63. Now, in writ petition 63, what are the relief sought? Your lordship will kindly see also the allegations, what are the allegations in the writ petition. They allege, and these are just in conformity with the order, my lord. I have already read out to your lordship, my lord, the order that was passed on that day. In WPC 63, they allege that there are violations of certain rules in the bylaws, and therefore the conduct of election has been vitiated. Now, kindly see what are the relief asked for. They ask for a certiorari, a quo warranto, a mandamus, and fresh election. That is very important. Now, in that circumstance, on 19th of February, the Honorable Court passes an order that the election will be subject to outcome. Then on 24th of February, the election is held. Now, in between, Miller, there are some events which take place from 11th of February, which is reflected under the head writ petition 97. 11th of February, Miller, the honorary secretary requires submission of the names of the representative, and a meeting resolution is adopted. What is that meeting resolution? My learned friend has shown that to your lordship in page number 132, and he has challenged that he has alleged many things regarding the illegalities in the meeting resolution. What I am on, my lord, without entering into the dispute whether it was correct or incorrect, kindly come to page 133. Has your lordship got it, my lord? Page 133. Kindly note the names at serial number 4, 10 and 12. Four, 10 and 12. These are the persons, my lord, who signed the resolution in attendance, and they are now writ petitioners here. Writ petitioner number 4, 6 and 3. Now, you participated in the election, in the meeting. You also signed in acknowledgement of your attendance, and thereafter you come up in the writ petition complaining that there are so many irregularities and irregularities. Basically, my lord, it's an election dispute where there is a fight between two factions.
Same thing happens here, Delhi. You make an argument, we pass an order, and then you go to the appellate court and say that we were not heard properly, we were not, the submissions were not recorded.
My lord,
No.
my lord,
It's the
that,
usual process.
my lord,
What will you say?
no, my lord,
The honorable judge did not hear us.
my lord, kindly see, here is an acknowledgement of the resolution.
It's okay.
It's an acknowledgement of the resolution. If I do not agree to the resolution, my lord, why should I sign and subscribe my hand? After accepting the resolution, you cannot come back and say that, no, this is manipulated.
Your submissions cannot be accepted. The simple reason is, you see, in 11.2, you give an attendance of meeting.
Yes.
Therefore, what you do is you take attendance separately. Then you join these two and then make it that the resolution is signed by everyone.
No. Kindly see.
You see, I have been, when I was at your stand, then I was members of many associations.
No, my lord, if it is to be so of an allegation, we cannot assume things, my lord.
No, that's okay, but
Although I'm not joining issue on this, my lord, but I'm trying to just show that how the factional fight is being given a color of an election dispute. It's a factional fight which is being given a color of election dispute.
that's okay, but
Now, kindly see, there is no allegation in the writ petition in 97 that this was manufactured, later produced, as your lordship is now suggesting, my lord. To that extent, my lord, with great respect, I will submit, my lord, there is no allegation in the writ petition. Now, your lordship will kindly come back to the trail of events, my lord, that I have just now submitted to your lordship. Here also, my lord, after the
please tell
election,
me, have you ever seen a resolution where in the attendance sheet, like here it is written, attendance of meeting, have you seen any resolution signed like that?
no, my lord, I am not on that. I am not on the merit of the matter. Only I am trying to show that these are the persons, my lord, whose signature is there, and they are not disowning it. They are not disowning it. They do not say in the writ petition that we were not present, our signatures were manipulated, it was manufactured. They do not say like that. Now, if your lordship will kindly see the next event, my lord, in the chart that I have submitted, ultimately the result is declared on 24th of February, and they filed the writ petition 97. Now, kindly note the prayers in the writ petition 97. Here also, my lord, primarily they seek stay of the election result. Then they seek appointment of respondent number 8 as chief advisor. They challenge it. They seek a mandamus for appointment of committee of administration, and here also they seek fresh election. Now, on the same prayer, can you maintain two writ petitions? Your lordship will kindly turn to the next page. Kindly see the interim relief which they ask for.
Yes.
Kindly see just the chart of events that I have given. The next page. Interim relief, what they ask for: stay of the election result, appointment of ombudsman, freezing of bank account of so and so, restrain the operation of the bank account, appoint administrator. This appointment of administrator is also one of the prayers. The management of accounts is also one of the prayers in writ petition 63. Kindly see status quo of management of funds. So just by interpolating and refashioning the words, Miller, they are asking for the same relief in a second writ petition. And it is not the end, Miller. After the election result is stayed by the Honorable Court on 12th of March 2026, they come up with a third writ petition, which is 118. And in the third writ petition, they take a very interesting stand. they say that after declaration of the result of the election, the body members, they became functus officio. And therefore, they could not make any interim arrangement to run the show in terms of the orders that were passed on 13th of March and 17th of March. That is their stand in the 118. And kindly see the prayers. Here also they ask for appointment of administrator. Same prayer which your lordship has noticed in writ petition 97. And the stay of the orders, which honorable court eventually grants. Lord, my humble and respectful submission is this. In the context of an election of a society, it's a registered society. Who are the petitioners before your lordship? Petitioners are the constituent voters. Constituent voters from the affiliated associations. What is their maximum right to contest the election and to cast their vote? They make a complaint to your lordships that their rights have been infringed. How? By not following the mandate of the bylaws. If it is so, then which right of yours has been violated? Have you been prevented from contesting the election? Or have you been prevented from casting your vote? Or you have been wrongly denied a representation. Which right of yours has been violated? It is only lordship, whenever your lordship will pass an interim order, my lord, an interim order is only with respect and in aid of the final relief that your lordship grants. An interim, by way of an interim relief, you cannot ask for a distinct relief which is different from the relief asked in the main writ petition. Now, in the main writ petition is 63. And the maximum thing that they can get in the entire of these three cases is a fresh election. Suppose today your lordship holds that the election is vitiated. Then what the maximum they can get? A fresh election? Now, in getting a fresh election or in giving them a relief of fresh election, what right of theirs are being protected by virtue of an interim order? Their rights are very, very crystallized. Right to vote and right to contest. Now, by passing the interim orders, which of these rights are being protected? On the contrary, if your lordship will see, practically your lordship is stalling the functioning of a democratically elected body. So my respectful submission is that the balance of convenience is never in their favor. Maximum they can get is the fresh election. Now, by passing these interim orders, my lord, none of the determination is being taken care of. None of their rights are being protected. Your lordship protects only the rights in the interregnum by virtue of an interim order. So here is no protection of their rights. Rather, it is curtailment of our rights, my lord, for which, my lord, we have filed the application for vacating stay. Now, as far as the question of functus officio is concerned, my lord, that day also I submitted that there is a latest judgment by the Honorable Supreme Court. The lordship will kindly see this. Well, the concept of functus officio is applicable only to judicial and quasi-judicial bodies, not even to state government executive functionaries. Well, I have marked the paragraphs, my lord, there. For shortage of time, my lord, I will not read it in the entirety, but I will just highlight the paragraph 42. Which your lordship will find at page 38 of the judgment. My lord, on the top of the page, my lord, relevant paragraphs I have marked. Paragraph 42, your lordship will kindly see. It cannot be disputed. Has your lordship got it, my lord? It cannot be disputed that the rule-making power of the legislature cannot be curtailed or nullified by application of the concept of functus officio. The principle, this is important. The principle of functus officio normally applies to a judicial forum or a quasi-judicial authority and would have no application to the rule-making authority which is within the domain of the state government. Now, something which is not even applicable to the state government, how can you make it applicable to a registered society? This is, my lord, totally unheard of, and there is a series of judgment, my lord, which this Honorable Supreme Court has referred to in this judgment, my lord, which lay down the principle that the concept of functus officio is applicable to only a judicial office and a quasi-judicial authority or tribunal. It does not apply anywhere beyond that. Today, your lordship passes a judgment, your lordship becomes functus officio. Unless and until, my lord, the law permits the court to review its judgment or modify it. In absence of an enabling power, my lord, the functus officio rule will come into application in respect of a judicial and quasi-judicial body. So by projecting a case, it cannot be said that since the election was over, you lost the mandate and you became functus officio, and therefore you could not even make an interim arrangement. What we have done in writ petition 118, since there is an order of stay of declaration of result of election, we have constituted a short gap arrangement so that the association can work. You cannot bring the concept of functus officio to say that even this is not permissible. My lord, may I just give your lordship this demonstration? My lord, what is this association? This association is a body of few members. Who are the members? Under the constitution, my lord, there can be 4 types of members. Number 1, life members. Number 2, district affiliate associations. Life members do not have any right of vote. District affiliate associations, which the writ petitioners are, they have a right to vote. Then there are international sports members. Then there are domestic sports members. These are the members. In this association, there are altogether 11 members. Now, these 11 members, amongst themselves, they decide that how the functions of the association is to be governed. They, for the purpose of governing the function, they create a apex council. And this apex council is constituted by way of a voting. Your lordship will kindly see rule 16. All the powers are at page 100. Has your lordship got it, my lord? Rule 16. All powers of governance, management, and decision making shall vest in the general body. So, general body is the body which is comprising of the members. Now, this general body, to perform the activities, my lord, they elect a particular body. Supposing, my lord, your lordship is holding this office, my lord, but to render some executive function, your lordship is authorizing somebody, some entity, to carry out the function which has got your lordship's permission. This is the constitution of the Apex Council, about which your lordship will find at Rule 12. And page 97, your lordship may kindly turn to. 12A says that the affairs of the association shall be conducted, managed, and administered by a governing body called the Apex Council. First of all, there is a general body in which, my lord, all the powers of the associations are vested. And the general body authorizes the governing body to carry out the functions and manage the affairs. So that is the Apex Council. And Apex Council members are elected by way of voting from the constituent members. This is the case. Now, if you are elected members, what is the effect of the declaration of result? Stay of the declaration of the result is that the managing body, the election of the managing body, result of the election of the managing body is brought to a halt. Does it mean that the association itself will evaporate? Ultimately, the general body is there. General body is there, and general body can, because all the powers are vested in the general body. So we pass an order that since, and order is very specific, till the time the interim order is vacated or the writ petition is disposed of, the day-to-day functioning will be looked after by this team. You cannot bring a concept of functus officio to nullify that. This is absolutely, my lord, irrelevant consideration at all. Therefore, my lord, my submission will be in the 108 application, IA 108, which arises out of writ petition 118, the interim order is wholly uncalled for. So, and out of that, my lord, the writ appeal 35 is before your lordships. So that 12th March order in the writ petition 26th March order in writ petition 118, that deserves to be modified. This is my submission in respect of writ appeal 35. Now coming to writ appeal 36, my lord. Well, facts are same everywhere, my lord, only the orders are different. That's why, my lord, there are two appeals. They have, what is their complaint now? In 97, they have extensively argued, my lord, writ petition 97. Their complaint is that the election officer was not appointed in time. We did not know about who was the election officer. We could not raise our grievance, etc., etc. There are violations of bylaws and etc., which we could not project because we did not know. In support of that contention, my lord, they have referred to the page number 389 in their affidavit in opposition. And this all document is also a part of the record in the writ appeal. It is not that there is any document has been left out or any document has not been provided to your lordship. Maybe for the purpose of making their argument more comprehensive, they have prepared their own set of documents, but these are all part of the writ appeal memo. Now, in this objection, my lord, which they have filed on 24th, on the ground, no, the date is 24th on the last page, 391. It is dated 23, but it was submitted on 24th. And they also say in their affidavit in opposition that they had submitted it on the spot, meaning on 24th. So in this 24th application also, your lordship will not find any of the allegation which has been canvassed before your lordship. By showing the voter list, it has been canvassed before your lordship that the voter list contained persons with disputed membership. Somebody who is not a president, but he has been projected as a representative, etc. This has been the submission of the respondent side. But in this complaint, my lord, there is not a single whisper that some candidates which were being put forth in the election or the voting rights, whose voting rights were being examined, there was any dispute. So it's a case made out, my lord, by going beyond the records, my lord. So far as the question of disqualification is concerned, my lord, Rule 36(3), your lordship has seen that the Rule 36(3) requires them to raise it before the electoral officer. They raised a complaint on 23, which was accepted on 24th. Where is that statement? Where is the complaint that these member, president number one, respondent number, the respondent number one president is disqualified and therefore he cannot go for voting? It's not there because, and why it is not there? Because till the time the election was held, as I said in the beginning, my lord, it's a factional dispute. For their vested interest, my lord, your lordship knows. Even the political parties, they change their allegiance. So it is the same kind of a thing which has happened here. So it will not. Now, as far as their knowledge of appointment of the inquiry officer, electoral officer and other things are concerned, my lord, I'll just show two documents. Your lordship will kindly come back to the writ appeal 36. Notification. And in writ appeal 136, 36, your lordship will kindly come to page 238. Is a document, my lord, issued by the electoral officer on 9th of February, giving a schedule of election. Every election, your lordship knows there are date of nomination, date of acceptance, date of rejection, etc. The election officer publishes it on 9th of February. What has been their complaint? That they do not know who is the election officer and when it is done. Now kindly come to page 140. The last paragraph. The PDCA was suspended on the evening of 9th February, just minutes before the election was notified.
You're reading which page?
140. I'll just read the paragraph once again, the last paragraph, one sentence. Has your lordship got it, my lord? 140. Kindly mark this statement, my lord. The PDCA was suspended on the evening of 9th February, just minutes before the election was notified. Now 9th February is the document as page 238. How do you say that you do not know about publication of the election notification? You know everything, but you give a different color to the court and make out a story that election officer was there only for one day. They have also shown one document, page 237. And by showing page 237, it was their statement that it was hijacked by me. If you know that 237 is the only document of election notification, 237 is dated 7th of February, signed on 16th of February. If you know that this is the only document about election notification, why and how do you write at page 140 that on 9th of February, minutes before it was notified? I am not entering into the other areas, my lord. These are wholly disputed questions of fact. Therefore, my lord, it's an election dispute where apparently, my lord, the petitioner is playing hide and seek. And on some disputed questions of fact, my lord, they are coming to your lordships to invoke the writ jurisdiction. Will your lordship, in exercise of 226 power, go and do a fact-finding inquiry? What are the documents in their possession? They have given some WhatsApp chats. I do not know the genuineness of this. I am yet to make a statement make a stand on the merit of the matter. So you give some WhatsApp chats, photocopies of some WhatsApp chats, photocopies of few signboards. Where from the signboards have come? From whose office it was taken? Nothing. And based on these two things, you are raising a question of disqualification and all. Where is your question of disqualification raised before the electoral officer? As per your statement, you know that on 24th there was an electoral officer. Where have you said to the electoral officer that this gentleman is disqualified? There are 8 respondents in the writ petition, my lord. All the time your lordship has been hearing about this disqualification of only respondent number 1. What about the election of the others? For assuming for a moment that their contentions are valid and correct, can the election of the other respondents be put at halt? The entire election process is put at halt. I will show 3 judgments, my lord. The consistent stand of the honorable courts across the country, so far as election disputes are concerned, hands off, go to civil court. My lord, I argued last year only, December, in Meghalaya Cricket Association's case, my lord, there was also an election dispute, and it was a case I argued for the Meghalaya Cricket Association. The writ has been disposed of without any interference. The reason being that in the election disputes, the questions are essentially disputed. So for the writ court, it is not possible to find out as to which fact is correct and which fact is incorrect. You are saying now, in the submission, it has come from them. By showing the voter list, they have said that these members are not president, these members are not secretary, etc., etc. What is the pleading in support of that? Neither in the reply to the 108 there is any whisper, nor in the affidavit in opposition submitted today. There is only a general statement made in the affidavit in opposition that the voter list has been manipulated. Where is the statement that particular this person, some Tashi or some Khapte, they are not the president, they are the secretary? Nothing. On the basis of this kind of an instruction, if a petition is filed and fought, well, the court will, it is obvious that the court will fall in error. Well, I'll sum up by showing the citations. Well, I'll not trouble your lordship to go through it because of paucity of time. More copy. Well, the first decision that I will submit. First decision, Miller, that is also from Jammu and Kashmir High Court. A factional fight between two groups in an association. It's a very short judgment, Miller. Your lordship will kindly mark the paragraphs. Paragraph 12, Milord. And these are decisions, Milord, not, of course, Milord, everywhere your lordship will find the decisions are rendered by the single bench, because it does not usually go to division bench, but all these judgments are with the authority of the pronouncement by Supreme Court. Your lordship will kindly mark paragraph 12. There is no dispute to the trite proposition of law that writ jurisdiction of High Court under 226 can be invoked against a person or a body discharging public duties, provided it involves public law element for collective benefit for public. Well, there are two things. BCCI, the other day I had submitted that G Telefilms judgment, Milord. BCCI is not a public authority. It is decided by the Constitution bench, Milord. 5-judge bench decision in G Telefilms. What is the essence of the judgment is that, Milord, although BCCI is not a public authority under Article 12, still some of its functions can be amenable to writ jurisdiction. Why? Because those functions are essentially public in nature, infringing right of the public in general, like selection of the team, national team, representation of the national players at the national level. So these are the public functions where a writ jurisdiction can be invoked. But G Telefilms is very clear in paragraph 259 and 264 that all functions of this authority cannot be public function and cannot be amenable to writ jurisdiction. So here, my lord, from these judgment, I will refer to 12, 15, and 16. My lord, this is in pursuance of the Honorable Supreme Court judgment in St. Mary's case. Although you may be rendering some public action, all actions are not amenable to writ jurisdiction. Next case, your lordship will. Next case, my lord, that I will refer. It's a judgment from Delhi High Court, my lord. Here also, my lord, it was an election dispute of a society. Well, paragraph 3 and 4. Paragraph 3, the opening sentence is very clear, my lord. The court in so-and-so has considered as to whether a writ petition relating to elections of a society is maintainable before High Court. Wide order dated so-and-so, in this case, this court held as under. Well, thereafter the order is quoted, but the reliance is placed, next page, reliance is placed in the order of the judgment of the Supreme Court in Ramakrishna Mission case. And paragraph 30 is quoted, my lord. And this is the line, thus, even if the body discharges a public function in a wider sense, there is no public law element involved in the enforcement of a private contract of service. Now, election is essentially a matter, my lord, which relates to the internal management of the association. What is the breach? My lord, your lordship exercises 226 jurisdiction to protect breach of public duty. Protect breach of public right and enforce a public duty. Now, which
We'll continue at 2.
Yes, my lord.
Yes, you
my
have
lord,
to now
before-
sum up.
Before I sum up, my lord, only one correction. In the Supreme Court judgment which I have given with regard to Functus Officio, the paragraphs number are a little bit wrongly marked, my lord. It is instead of 42 from 46, it will be 42 to 44. The P. Rammohan Rao. Yes, your lordship may kindly note, my lord. On the top of it, I have marked the paragraph as 42 to 46. It will be 42 to 44.
Yes.
So I was reading from this Delhi High Court judgment, my lord. In this, Imran Hafiz,
You're relying on 43 to
42 to 44.
42 to 44. Okay.
Yes. In P. Rammohan Rao.
Yes.
Next, I was relying on. Next, I relied on the judgment in Sanjay Saraf case, Jammu and Kashmir Cricket Board. And now I was reading the Imran Hafiz from Delhi High Court. The lordship is holding the Sanjay Saraf case from Jammu and Kashmir High Court.
Sanjay Saraf.
Yes, from Jammu and Kashmir High Court, my lord. It is also with regard to election of the Cricket Association.
Okay. Yes.
My lord, the paragraphs are marked, my lord. Only paragraph 12, your lordship will kindly see 12 and 15 from that judgment.
Yes.
12, there is no dispute to the tried position of law that writ jurisdiction of High Court under so-and-so can be invoked against a person or a body discharging public duties, provided it involves public law element for the collective benefit of the public. In other words, the action assailed must have a nexus with the performance of public function or obligation. As such, it is the nature of duty performed by a person or a body which is determinative factor, and scope of judicial review is confined to the enforcement of public duty only. Now, election is not related to enforcement of any public duty. Paragraph 15 on the next page, your lordship may kindly see. If the present case is approached with the aforesaid principle of law, paragraph 15, your lordship may kindly mark. It is manifest from the case set out by the petitioner as also from the tone and tenor of the impugned order that it is a pure civil dispute and there is no element of public duty sought to be enforced. By virtue of the impugned order, respondent number 4 of action of WCC has been recognized and for the limited purpose of taking part in the voting in the forthcoming election of JKCA. By virtue of the order, so passed by so. So there was also a case of voting and the election, and the writ petition was filed. Referring to the Supreme Court decision, the JK High Court has said that it will not be amenable to writ jurisdiction. Next, I was referring to this Delhi High Court judgment in Imran Hafiz. Now, here, your lordship, my lord, I will read in the page number 2, second page, para 10.
Already noted. Yes.
Only 2 lines, perhaps. My lord, just before the quotation of the Supreme Court judgment comes, it has been held in a series of judgments rendered by the Supreme Court that for a body to be recognized as discharging public functions, the activities should be closely related or akin to sovereign functions performed by the state. Then, my lord, the Ramakrishna Mission case is referred. Next page, para 11. And the reference in KK Saxena's case is there, para 11, and the paragraph 43 of KK Saxena judgment is quoted. Last few lines, therefore, even if writ petition would be maintainable against an authority, which is state, under Article 12 of the Constitution, before issuing any writ, particularly writ of mandamus, the court has to satisfy that action of such an authority which is challenged is in the domain of the public law as distinguished from private law. Para 12, it is also pertinent to draw a sustenance from the decision in so-and-so versus so-and-so, wherein it was observed that bylaws constitute a contract between the society and its members and members inter se. The court went on to take a position that a mere violation of such bylaws would not lead to the invocation of writ jurisdiction. That is the reminder. So therefore, my lord, here also the complaint, as it is, if we on the face of it, if we accept that whatever they are saying are correct, then it is a complaint about violation of the provisions of the bylaws. So it does not become a public dispute as such. It's a private dispute between the members. That cannot be enforced through writ jurisdiction. Now, next case, Milord, it's a judgment from the Honorable Rajasthan High Court. It was a case of it was also a case of election, but of a chess association. It's a division bench judgment, Milord. The Lordship may kindly come to paragraph 21 at page 12. In case of Ramchandra, has your Lordship got it, Milord? In case of Ramchandra Chaudhary and others versus Roopnagar so and so, Honorable Supreme Court has considered the exercise of jurisdiction under 226 and observed as under 14.2. Conversely, disputes which pertain purely to the internal management, governance, or electoral process of cooperative societies do not, as a matter of course, attract writ jurisdiction, merely because such societies owes their corporation to a statute. Now, here is a case, my lord, it is not also a statutory corporation. It is a entirely private society, not even a cooperative society. Even when, my lord, it's a case of cooperative society election, my lord, the Honorable Supreme Court has said in this judgment, I'll refer the judgment now, that the internal management dispute cannot be subject to scrutiny of 226. I'll stop here and straightway take your lordship to the Supreme Court in Ramchandra, which has been referred in the division bench judgment, my lord.
Repetitive may not be required.
Yeah, but the proposition has, although it is only an extract, 14.1 has been quoted, my lord. Here, if your lordship, in this judgment, if your lordship takes the 14.1 to 14.9, my lord, the law will be very clear. It is entirely with regard to the exercise of this jurisdiction. The dominant proposition is this, my lord. Even if we assume for a moment that this association has been rendering some public duty, the internal management does not partake the character of a public duty. It is an internal management association of the office bearers, internal management of the office bearers. And on the general law about the law of election, my lord, your lordship knows it, but I must make this submission also. Your lordship has very recently seen this Tamil Nadu case, my lord, where there was one difference of postal ballot, and a writ petition was filed in the Madras High Court, where, my lord, the Madras High Court had exercised writ jurisdiction and stayed the election. Matter went to Supreme Court, my lord, and the Honorable Supreme Court went to this extent of saying that it is one of the preposterous case. The writ court should not have intervened. My lord, I am just placing the orders before your lordship's consideration. The reason is this, my lord, the general law as regards the exercise of jurisdiction vis-a-vis the there, my lord, the Honorable Madras High Court had taken the view that since for the purpose of consideration of one postal ballot, the dispute with regard to one postal ballot, since there is no mechanism provided in the Representation of People's Act, so therefore jurisdiction can be exercised. And on that analogy, my lord, the result of the election was stayed, because the next day was the floor test was there. But the matter went to Honorable Supreme Court, and my lord, this is the order by which, my lord, the order of the High Court was stayed. Not only the order of the High Court, my lord, the further proceedings of the writ petition was also stayed. So this is only demonstrative of the fact, and my lord, the judgments that I have submitted, this is only demonstrative of the fact that in election matters, usually the jurisdiction of 226 cannot be exercised. One of the reasons being, all election matters, my lord, the questions of facts are to be gone into, and it is not for the writ court to give finding on the questions of fact, because the writ court is otherwise not equipped to take evidence. Now, they have cited the voter list, saying that the voter lists are manipulated. And I have shown to your lordship that there is absolutely no pleading in the objection, no pleading even in the affidavit filed, just oral statements made. And there is no counter to this assertion. So you make certain allegations. Now, if are they choosing
This is
this?
paragraph, which paragraph you are relying on this Supreme Court order?
Well, Supreme Court order is only High Court order is annexed there, my lord. That's why it is voluminous. The Supreme Court order is only 1 page, my lord.
Oh, acha.
Last paragraph, your lordship. In the meantime, the effect and operation of the impugned order shall remain stayed, and further proceedings before the High Court in pending writ petition shall also remain stayed. We all know, my lord, your lordships may also have perhaps noticed this the judgment in the Madras High Court case, because it is only on that premise that no effective mechanism was provided in the Act, and therefore the stay was granted. So even in that kind of a situation, my lord, where no effective mechanism has been provided, well, the judgment has been stayed by the Honorable Supreme Court. Because the underlying jurisprudence in election cases have been from time immemorial, my lord. It has been that in election disputes, hands off. And the judgments which I have cited, although some of them are from single benches, my lord, this is reflection of this principle only. That if it is an election dispute, go and fight it out before the civil court. Or if you have got an internal mechanism in your case, in your bylaws, then fight it out there.
Okay, we'll have to close it then.
That's all, my lord. Only another one line submission, my lord, that I will make. That I have only said, my lord, 108, IA 108 arises from writ petition 118 and IA 110, na? 110 arises from writ petition 97. 108 is concerned with the order of 13th March by which a stopgap arrangement was made. Now, this stopgap arrangement cannot be stalled by saying that you don't have any authority. And that 13th March order, your lordship will see at page 122 in the writ appeal brief 35. It is only a stopgap arrangement till the time, my lord, the lordship decides on the on the application for vacating stay.
Page 132.
122. 122 in writ appeal number
35.
35. That is under stay because of the order by the interim order. So my humble and respectful submission is this, my lord, this interim order should be vacated. And so far as the 97 is concerned, my lord, 97 is stay of the election. That also should be interfered with, because ultimately if they succeed, my lord, there will be a fresh election. They cannot be given some benefit more than what they are asking for in the writ petitions. And on one issue, multiple writ petitions have been filed. How is it maintainable? 63 already takes care of every eventuality. So writ petition 97 and 118 practically, my lord, are, in my respectful submission, are misconceived. If they wanted to join issue, my lord, they could have done so in 63 itself by filing additional affidavit. They know that they know for sure that if these matters are taken into trial, my lord, they will not be able to stand cross-examination. So take a shortcut, get it done in the writ court. And the interim order, my lord, passed in the in the writ petitions, my lord, they have got no nexus at all with the final relief that can be granted to the writ petitioners. That's all, much obliged.
Heard. Mr. S. Datta, Senior Counsel, assisted by Mr. H. K. Nath, Learned Counsel for the petitioner, as well as Mr. J. Jini, Learned Counsel for the respondent. So arguments are concluded, order is reserved.
Instead of petitioners, your lordship may say that we are for the writ appellants.
No, appellants.
Appellants.
Right.
Good.
Item number 4 and 5.
May it please your lordship. My lord, the
Yes,
My lord, the matter relates to settlement of some contract. In fact, my lord, on a previous round of litigation, this was decided by this honorable court. My friend appeared for the government and I had appeared for the appellant. And in fact, my lord, he had been very fair in giving a consent and a consent order was passed. But somehow the department took some different view. They went to Honorable Supreme Court and saying that the consent was not there. So the Honorable Supreme Court has returned the matter for fresh decision on merit. But as a matter of fact, my lord, it was on consent of both the parties and he was very fair, my lord, in making the submission. But then the respondent department took some other view. So it has come for fresh decision on merit. So if your lordship permits me, my lord, then I can open up to the.
not today, we'll not have time.
Not today, my lord. My
We'll
lord,
have Single bench.
only small correction, my lord. What the land council says, my lord, is correct, but I have given consent, my lord, where, my lord, no bidder, my lord, they succeeded, my lord. In that
Anyway,
count,
my lord,
in
since
that
we'll
count
be-
only, my lord, I considered for fresh NIT, my lord. Rest, my lord, I have not given any consent, my lord.
In any case, my lord, so since it
Anyway.
has to be hard afresh, my lord, it will,
Yes.
lordships will hear it fresh. In fact, my lord, your lordship, this particular bench had the occasion of taking the matter on the first instance. The stay order was passed by your lordships. So today, since time will not permit, my lord, it will be difficult. Your lordship may post it for consideration sometimes in the third week of July.
Third week of July.
There will be a single bench day on Friday.
No, it is
No.
Sorry.
July.
After break, you mean?
After break.
After break.
It won't be
All right.
27th.
Yes.
After break, means
27th, my lord, it will be Monday, so there will be no division bench probably.
What is the date you're suggesting?
27, 28, 28, 29, my lord. Or 21, 22, my lord. Either of.
You know?
21, 22?
My lord, 22 won't be because it's Wednesday.
Correct. 21?
No. 21 is little difficult. My lord, can it be on 4th of August? Or
Mm,
That will be better.
because there may be some.
No, not that. What happens is that now vacations are coming, all vacations would be now adjourned till the first week.
my lord,
First week after reopening.
if this is so long, my lord, perhaps the tender might become infraction because it's a period is there.
Okay.
It's for 1 year or 2 years, something like that.
Okay.
my
No,
lord.
no, that is all. That is long time it was gone, my lord. That is long time gone. So that is not an issue.
Okay, then we take it up on 28th.
Or
28th,
Hmm.
28th, okay.
28th, okay.
28th of July or
July.
June? July. 28th. Correct.
Mr. S. Datta, Senior Counsel, assisted by
IDAS.
Ms. I. Das, then Counsel for the petitioner, and Mr. R. S. Nawam, then Additional Advocate General for the State, are present. To stop. Due to positive time, the matter could not be taken up for hearing. As agreed to by both sides. List on 28
07.
7 2026
For hearing.
for hearing.
Item number 11 and 12.
Maybe, Your Lordship.
Lordship, I'd like to mention item number 3.
3.
Yes, Lordship.
Okay. When?
Lordship, I am praying that this matter may be listed after 2 weeks. I have informed the petitioner. I'm on behalf of T. Dabum Standing Council Project.
Okay. Both sides are represented with consent of the other side. The Learned Counsel for the Education Department pays for adjournment. Prayer is allowed. List after 2 weeks.
My lord, I would like to mention item number 10. So this standard matter, as a counsel for the petition was physically unaware for quite a long time, therefore the step could not taken off. Sole private respondent. We shall take the press step. Said Dusty Service.
Just see item 10.
Item number 10.
You are paying for some time to take steps.
Yes. Actually, this matter came up after 6 months, I think.
So your name?
T. Dukom.
Hmm?
T. Dukom.
You're not there on record?
Actually, he's my friend. No? So he just sick, so he could not appear. So informed me that why not.
Okay, just record his name, Master.
T. Dukom.
T. Tocom, then counsel enters appearance on behalf of Mr. C.W. Mantaro.
Yes.
Then counsel for the petitioner. So it is submitted that due to inadvertence, steps has not been taken for service of notice on response number 5. So he undertakes to take steps.
My lord, interim maybe please continue, and Dusty Service.
He undertakes to take steps by 12/6/2026 for service of notice on the respond number 5. Next para. Accordingly, the petitioner shall take steps by 12/6/2026 for service of notice on respond number 5 by speed post with AD. And in addition, notice shall also be served on respond number 5 through Dusty mode by routing the process through the registry of the court, and upon service, an affidavit of service shall be filed prior to the next digital listing. Next, notice is made returnable on so and so. So interim order passed earlier stands extended to the next date of listing.
3 weeks time maybe.
List on. Take steps, otherwise we'll withdraw the interim order.
Yes.
You just make a note there. It is made clear that if steps is not taken, the interim order shall not be extended on the next date of listing. Okay, next.
Lordship, here is one unlisted matter, WPC 197 of 2026. Can the matter may be listed tomorrow?
Just yes.
May Your Lordship? Your Lordship, I beg to mention item number 4. Your Lordship, I pray that the matter may be listed after 2 weeks.
This is the old matter.
Your Lordship, I am for the petitioner.
You see item number 4. Give the record of item number 4. Okay, pleadings are exchanged.
Yes, Lord.
Okay, both sides are represented. The pleadings are exchanged. First of all, the prayer made on behalf of the learned DSGI, the matter stands adjourned today. List on.
Your Lordship, I have one fixed date. Earlier also two occasions,
Okay.
matter was adjourned.
When? Tell us the
24th
date.
June, 24th June, Your Lordship.
24/6/2026. Okay.
Much better.
Much obliged, Your Lordship.
May I please, Your Lordship?
Yes.
My Lordship, the petitioners are state forest officers. They are aggrieved by the fact that, my Lordship, they have been recommended, proposal has been sent for their promotion to Indian Forest Service. But till date, the respondent authority, particularly Union Public, yes, my Lordship. Every year, the UPSC select list should be prepared. But till date, they have not prepared the select list, and that's why,
When was the last promotion exercise made?
my Lordship, we have been recommended for the select year, which I have stated for selected 21, 22, and 23. We are entitled for 21, 22, and 23. And for the
Mr. SBA Laskar and counsel for the petitioners. Next para. Same para. Also heard Ms. P. Pangut and government debate appearing for all the respondents.
1, 3, and 4, Your Lordship.
1,
3, and 4.
1, 3, and 4. Who for the others?
On behalf of DSGI, respondent number 2.
And the staff selection, UPSC, you will be for 2 and 5. 5 is UPSC.
Yes.
You are this DSGI will appear for him also. And who is appearing for the selection committee for Forest Service?
is represented by the chairman UPSC, my Lordship.
So you will be appearing then for all the other respondents, 2,
You don't need to.
5, 6, and 7.
5, 6, 7.
Okay, record her name
They need it.
on behalf of Mr. M. Katul and CGC for respondent numbers 2, 5, 6, and 7. Next, the petitioners project that they had become entitled for promotion for the selection year, for the select list years 2021, 2022, and 2023. So it is submitted that every year a select list is required to be made, and the authorities are required to conduct the exercise of promoting the members of the State Forest Service of Arunachal Pradesh belonging to joint AGMUT cadre to the next higher post of
Indian Forest Service.
Next okay, so for the Indian Forest Service, first off, it is projected that due to long delay in undertaking the exercise, the petitioners are being deprived of timely consideration of appointment or promotion to the Indian Forest Service, adversely affected their future prospects. Next, para issue notice returnable on so and so. As all the respondents are represented, extra copies of the writ petition be served on the Learned State and Department, Learned State and State Council as well as the Learned CGC by 12/6/2026. Next para is the issue involves the exercise to be undertaken for promotion, the court expects the respondents to file their affidavit in opposition by the next date of listing. Next, the pendency of the writ petition shall not be a bar for the appropriate authorities to undertake the issue of promotion. Next para. List on so and so. You'll give the certified copy to whom?
My lordship.
Who is the authority to move?
My lordship, the authority, my lordship, the UPSC is to conduct the meeting, my lordship. There is a selection committee which prepared the select list. And out of that select list, the union government, my lordship, the Ministry of Climate Change, appointment is.
The petitioner shall send a certified copy of the order to the respondent of 5 to bring the order to the notice of the said authority.
Next item also a similar matter, only the difference is that the next item, the petitioners are retired in service. So the claim is that the national they should be considered and their pensionary and other benefits should be considered. Only that much is the difference, my lordship.
Same as last order, but here there will be the petitioners are retired
State Forest Service.
State forest officers and claim
They have been already proposed and recommended, my lordship, by the
and
state.
claim to be granted the notional promotion for the purpose of their retirement benefits. So it is submitted that the proposal has already been sent for the post facto notional promotion. The rest of it will be same. Okay. How many petitioners are there?
My lordship, there are four petitioners.
Okay. Same order, same date.
Sir, next date.
Highly obliged, my lordship.
Item number 5.
Oh, that yesterday's matter.
Hold dagdung ka man na website.
Yes.
But I will be appearing for the private respondents.
Okay.
If your lordship permits, judgment relied upon by learned senior colleague, Yapung Konya has been distinguished by division bench of this court, depending on the facts and circumstances of the case. The difficulty is manner they have not filed an affidavit. If your lordship permits, I will place the document.
No, because you see the what you call the issue involved. Here is this court has already said because the Supreme Court says the gave the liberty to the petitioners for an early hearing.
Yes, my lord, we can, if your lordship permits me to, without filing an affidavit, you will permit me to produce a document, my lord, then I can argue today itself.
Yes, yes. Just give a copy to Mr. Patil.
My lord, I got two more judgments here.
Ibutan mo kailang yapon ko ni.
Kipa yapon ngayon.
Mamahi datang kipa rin yan.
Kipa rin niya. And para 39. In the present case, from the perusal of the record placed by the state respondent, this court is of the view that the action of the respondent in issuing the impugn order under such and such dated 26/4/2018 of the Rural Works Department of the state annexer 10 to the writ petition is based on the extraneous consideration or for achieving an alien purpose and with an oblique motive. It is found that the said order dated on 26/4/2018 has neither been issued in normal course nor in public or administrative interest or in the exigencies of service, but for other purpose, that is to accommodate the respondent number 5 for undisclosed reason made for purpose which is modified the said administrative action of the RW Department of the state in issuing the said order dated on 26/4/2018 is in clarable exercise power and was not just and fair.
Kaya hihilita lang nipong ko na same, papa same.
And another judgment, copy biton.
Kopi dan kopi.
Oh,
Dumulo kamang kopi kamang.
ang kado.
Kung the moment ngayon.
Copy lang.
Ito lang iya.
Here in this case, my lord, this is reported 2021, volume 1, Guwahati Law Report, 449, Ributama. Here the petitioner is a regular AC, RWD, Department of Engineer, and the person number 2 was also a AC, but he was on, I'll give, functional. And his substantive post was executive engineer. So the transfer was made to the petitioner and he was the reliever. Though in that case, the transfer order was set aside and was. That is the relevant part is para 62 and 63. Apa kamain?
Kamana na kamana mo pindulan.
Ano ka pa buman din? Ay, ano po dito? So that case is very much covered in my case. Here, he is though he is written as in charge of the DF CSO. His drawing is still the salary of the SDF CSO. He is not the cadre of my cadre. So interset transfer means it is always between the cadre. So he is not belong to my cadre.
Okay, that we have already heard yesterday.
Malified from the.
That we have already heard
becomes
yesterday.
a modified.
That we have already heard yesterday. Because Mr. Patin, again, if you insist on a full-length hearing, then we'll not have time.
No.
Again,
no,
the matter would be adjourned.
No, whatever to submit, I have submitted it already, and all the two
Yes, that's
rulings
right.
I have submitted. All these are
Because if we
confirmed.
prolong the hearing, then even today it will not be over.
So that they should let us hear it tomorrow. Because
No.
the transfer matter.
This is not the only matter I am hearing. I'll devote 2 days, not more than that.
It is a transfer case, and Supreme Court has also directed.
So therefore we are asking you
dispose the case.
to
Yeah,
shorten
can
your
I-
argument. Yes, if you don't hear, then the matters will be again adjourned.
My lord, in fact, yesterday I was directed to come up with the judgments that I relayed. Your lordship,
Just want to.
my lord,
This is.
I don't want to burden your lordship much with this judgments because
This is being stupid.
Yes.
just for argument's sake, my lord, one issue was raised, my lord, that this private respondent was
he has been dislodged only to accommodate the private respondent, my lord. That matter, my lord, Silpi Bose case clearly covers on the basis of this application, my lord, made by this for addressing the grievances of this petitioners, my lord, the employee. When transferred merely, my lord, on that ground cannot be this interfered, my lord. Silpi Bose clearly covers that, my lord. Your lordship, another issue was your
Which
lordship.
paragraph?
Paragraph 3 and 4 will answer it, my lord. Paragraph 3 and 4, my lord. Your lordship. That was the main issue that one of the main issues that he raised yesterday. And another issue was your lordship, Keder and this Konya and one Hibu Tama issue, my lord. And regarding, my lord, this political interference, my lord, the record I produced yesterday, file nothings and
No,
all
but
that,
you see, Silpi Bose doesn't help you in any way.
my lord.
Number one, it's different on facts. You know under what circumstances Silpi Bose was passed.
My lord.
In Silpi Bose, the issue was that the authorities deemed it appropriate that in rural schools, the lady teachers would be in their respective areas. Correct.
My lord.
So if for the lady teachers, this was exception carved out, where the government said that let them remain in their own areas,
my lord.
and therefore the transfer orders were made. What the High Court did in Silpi Bose was it did not interfere with the transfer on that ground.
My lord.
It interfered on the ground that the transfer orders are bad. And therefore, Supreme Court was surprised that how can this be held bad?
Yes.
And therefore, it says that you don't interfere in transfer orders.
My lord.
But it doesn't say, this is not an authority on the point that if people are of different cadre, they're not.
No, my lord, I am not there, my lord. I am coming to that different cadre point, my lord.
Yes, yes.
Actually, your lordship, this honorable division bench in this Tabang case, my lord, division bench of this honorable court, my lord,
Who had cited the case of Bijoy Patin? Bijoy Patin was cited by whom?
Huh?
Bijoy Patin.
Yes, I'm a,
You cited.
my lord.
I'm for a petitioner.
No. This
Okay.
this order is 25. WA 25 is produced for what?
Nyapung Konya in
WA 2021, my lord.
Okay.
That is produced by me, my lord. I am relying on that, my lord. Read Appeal 21, 2025, my lord.
No, 25 or 26 is Bijoy Patin. Was the same case. Okay.
Hibutama.
And who had cited this Nipung Konya case? Niapung, Niapung, Niapung Konya. Who had cited this?
Petitioner, he is relying on that, my lord. That is a 2016 case,
No,
my
no,
lord.
since I did not note, I am just asking.
My lord.
Linya.
I mean, this is by.
Kiparinya.
Yes.
We're relying also on Kiparinya. India Kiparinya.
Yes, Tabbing. What do you say?
Your lordship, please come to page para 20, 21, 22, 23, and 25, my lord. Here, my lord, Hibutama and this Nyapung Konya, my lord, has been differentiated, my lord. by the division bench, and even this petitioners, appellant petitioner, my lord, was agreed by this division bench order also, my lord. He even went to this Honorable Supreme Court, my lord. Supreme Court in single strike, my lord, single stroke, my lord. Your lordship, it is a Supreme Court order. In single stroke, my lord. Again, Supreme Court has stated, my lord.
No, you see, we are making a statement which I am not able to follow. You are referring to 21 to 25 for what purpose?
My lord, may I read it, my lord?
No, just tell us what is it for,
My lord,
for what purpose you are relying.
My lord, it has been said that in para 21, it has been said that
We can cover this 24. We're making 24 to differentiate the case. 24 in paragraph number 24 is very important. In the present case, the appellant has failed to show any adverse consequence on his career or prospect or any prejudice nor any mala fide is alleged or violation of any statutory rules. My lord, the difference of this case that has been cited is that one, we are alleging statutory violation, and secondly, we are also alleging mala fide, my lord. So this case is irrelevant, my lord, and it will be a waste of time to just go into that. But 24 is the core where it's differentiating between our case and this case. We are alleging mala fide. We are saying the transfer has been done out of to accommodate respondent number 4. Therefore, the mala fide element is present, Your Honor.
may I complete my argument?
No, let him complete. He did not inform when you are submitting. Complete.
Because 24 is the differentiating element. Otherwise,
then adjourn it. List next week. As there is an interference by the Learned Counsel for the petitioner, when the Standing Counsel for the Education Department is making his submissions, list on.
Can it be on 22nd, ma'am?
22/6/2026. I'm spending my extra time to hear. This is not expected. This is not expected. You can't disturb the other side. I have taken a serious offense of indiscipline. You see that the first, you all are young lawyers. You must always remember, under the code of ethics, the first principle for the counsel is that you give respect to the other side. That is the first principle. If you don't show respect to the other side, you don't expect respect either. So it doesn't help you. It damages your purpose.
my apologies.
Never do it. I'm spending my time, extra time to hear you. Then I have taken up yesterday, I have taken up today just because of the Supreme Court orders to take the matter for hearing. Yesterday, because of this, your matter and one other matter, I had been sitting in court till 6 o'clock in the evening. Then why I'm taking up this extra effort? I would have stuck to my time for 4:30. I'm doing so because of the urgency, and then you disturb us. I have 2 years, but I can't hear 2 of them. I have my limitations.
Monday.
Your lordship.
22.
Let us
22.
treat it on Monday.
22nd.
Okay. Oblige, my lord.
Item number 6.
Yes.
Yes, Your Lordship.
Pleadings are exchanged.
Yes. We have filed our affidavit on 17/3/2026, Your Honor.
What is the stand by who is for the Union of India?
DSGI, Your Honor. I'm appearing
You
on
are
behalf of
appearing
DSGI.
Okay.
Yes.
Okay, none appears on call for the petitioner. However, Mr.
T. Mehta, Your Honor, Your Lordship, T. Mehta.
T. Mehta, Learned Counsel, appears on behalf of the Learned DSGI. For injured justice, the matter stands adjourned today. List on, give a date next week.
Sure, like
19 June. Item number 7.
Wait. My lord, the pleadings have been, the respondent filed their affidavits. My lord, can it be fixed for admission hearing, my lord, after 2 weeks?
Okay. Both sides are represented as the case is ready as regards service and affidavits have been exchanged. Is the matter for in the admission column on
After 2 weeks, my lord?
after 2 weeks.
Okay. All right.
Item number 8.
May I please, Your Lordship?
Yes.
My lord, I'm appearing for the petitioner in this review petition, my lord, where I'm praying for review of Your Lordship's order at page 86, my lord. The order starts from, my lord, page 80A. My lord, may I just apprise, my lord, what the writ petition was, my lord? My lord, in the writ petition, my lord, the basic grievance of the petitioner was that there was a valuation report in respect of his property, which was left out from compensation, my lord, list of compensation. Though the valuation report was done, my lord, that computation of valuation report was not as per the 2013 LAR Act, my lord. That was the grievance, my lord. Now, my lord, when this writ petition was taken up in the motion stage, my lord, an instruction was sought from the government council, my lord. And the government's councils placed an instruction saying that there has never been a notification of acquisition for this land, my lord. And the this instruction was directed to brought on affidavit, my lord. Your lordship will find your lordship's order at 3/4/2025 on a submission made by the council, my lord, representing the government, that since the instruction says there has never been a notification, therefore the writ petition is premature. Lordship finds paragraph number, my lord finds paragraph number 3 is the instruction which has been relied upon by the by your lordship, my lord. The learned additional senior government for the state, respondent has produced a copy of the instruction letter dated 27/2/2025 issued by the additional deputy commissioner Diran, and it is submitted that the writ petition is premature because the acquisition notification has not yet been issued. The content of the said letter dated so and so is extracted herein below. With reference to the subject and the letter under reference, I am directed to state the following: the
It's
land
okay,
properties
just-
of the petitioner is located.
No,
Yes,
don't
ma'am.
read. Just
Yes, madam.
Then
Now, my
what-
lord,
then what?
on that ground, my lord, my writ petition was disposed. Now, if your lordship kindly turns to page 91, my lord.
Yes.
Page 91, my lord, is the notification was already issued on 9th of December 2017, my lord. That was not within our knowledge. So the apparently, my lord, whether I say or not, my lord, the instruction which was placed by the additional deputy commissioner before this court was absolutely misleading, my lord.
Yes. For the government?
Yes,
You're
Lordship.
there?
Yes.
Then
Lordship, misleading intention may not be there, Lordship, but then somehow mistakes has happened, Lordship.
no, but then we'll have to drop also, we'll have to drop a sumo to contempt against this Hage Turung ADC West Kameng district.
Lordship, for the mistake, I apologize before this court, Lordship.
No,
Because,
no, that apology must
Lordship,
come by affidavit.
Lordship, because At that point of time, Lordship,
No, that's okay. We for the time being, we are, what do you call,
Lordship, may I pray? Lordship,
this is a review petition. Review petition has to
Review
be,
petition.
this has to be controlled, and we'll have to take up the this petition for hearing. But in the meantime, better have this Hage Tarung file an affidavit, otherwise it would be contempt.
Lordship, this Ace Tarung, he is not there in the with.
No, wherever he
Virat
is, you'll
anymore.
have to track him out, because you'll not, okay, even if he is retired, he is to come and file an affidavit.
Lordship,
He'll be saved only if he's no longer in the earth.
Lordship, other
Except for his death, he'll have to, wherever he is, he'll have to come and file an affidavit.
Lordship,
We take a serious objection to it.
Lordship, I understand that. And Lordship, here other prayer of the petitioner is that they may be allowed to file another writ petition on the same subject. Lordship, considering
That prayer perhaps, my lord, is,
No,
since
it is
if your lordship is satisfied,
if it is his choice, because the writ petition has been closed on a wrong notion,
Lordship,
wrong
of course,
instructions. So even if Mr. Kaushik wants to withdraw it and file it again, we'll permit that. If he
My lord,
wants to, with this
I-
writ petition, we'll permit that.
my lord, yes. What, technically, if a lordship is pleased with the ground of review, so
No,
if
it's-
the order is, my lord, yes, if the order is recalled, my lord, the writ petition will be restored, my lord, then it's upon the petitioner to decide, my lord, whether he would like to go on. But however, my lord, because of the wrong instruction, my lord, I have been made to suffer, my lord.
Correct.
Lordship,
But Mr. B. Kaushik, London Council for the review petitioner. Also heard. You'll be appearing for all the respondents?
no, Lordship,
I'm appearing for both the Union of India, for number 6 to 9.
And you will be for 1, 2, and 3. She will be for 1, 2, and 3. And your name?
K loyal.
K. Loyala. You are CGC.
Yes.
CGC appearing for respondent numbers
6 to 9.
6 to 9.
1 to 5, Lordship.
1 to 5.
Yes, Lordship.
Okay, 1 to 5. Next para. This review application is in respect of which page is the order? 88. That is the order dated
3rd of April 2025.
3/4/2025, passed by this court in WBC 72 of 2025. Stop. This court, relying on the instructions by letter dated 27/2/2025, issued by the then Additional Deputy Commissioner Dirang from West Kameng District, which is recorded, the contents of which is recorded in the said order, had held that the writ petition is premature. And accordingly, the petition stands closed with liberty to the petitioner to approach again. Next para. The learned counsel for the petitioner has produced copy of notification bearing number LM-169/2017, dated 9/12/2017, issued by the Secretary, Land Management, Government of Arunachal Pradesh, by virtue of which for public purpose for construction of double lane on BCT Road within bracket KM 167.000 to KM 174.000 semicolon KM 183.000 to KM 195.000 and KM 195.000 to KM 112.000 bracket close, falling under jurisdiction of the Deputy Commissioner, West Kameng District, Bomdila, was acquired by acquired under the provisions of Section 10 of the Balipara with /Tirap /Sadia, Frontier Track Zoom Land Regulation, 1947. Full stop. Next, therefore, the Land Council for the petitioner has been able to satisfy the court that the land of the petitioner, which is stated to be covered under covered by chainage number 173.540, falls within the
First one, 167 to 174.
First, falls within the acquisition made for the road within KM 167.000 to KM 174.000, covered by notification dated 9/12/2017. Next. Next, the learned, your designation to the senior government advocate, Ms.
Additional senior government.
Additional, Ms. G.A.T., learned additional senior government advocate, does not dispute the said notification dated 9/12/2017. Next para. Accordingly, the petitioner has been able to make out a case for a recalling of the order dated 3/4/2025 passed by this court in WBC 72/2025. Resultantly, the proceedings of the said WBC 72/2025 shall be restored to file. Next para. Before parting with the records, the court expresses its utter dissatisfaction and anguish at the false and incorrect communication white letter dated 27/2/2025 issued by the Additional Deputy Commissioner, Dirang, West Kameng District. So accordingly, they said authorities put to notice that in the event no apology is forthcoming by the said authority, wherever he may not presently be posted, the court reserves its right to issue proceedings of contempt against the said authority.
May I just one line submission, Lordship? Because this matter was issued and motion stage itself, Lordship. Only instruction was sought and petition copy was not given, Lordship. at that point of
No,
time.
that we don't know. He'll have to, you see, he should not have given any instructions to the court which is false. So we
Only
are still,
Honorable Court,
we are still giving you an opportunity to file an affidavit and atone for the mistake.
only
Then
Honorable Court's order of for Lordship instruction was forwarded to him, Lordship. Oh,
we understand, but whatever happened, you see, at times we require instructions. When we are passing an order now, we may require instructions by 6 o'clock. That is for exigencies of the issue involved.
Maybe
Correct.
without the writ petition, Lordship, there might have.
We understand, but he takes responsibility of producing records. You see, if somebody asks me for a report without knowing, shall I start giving report left, right, and center? He has to atone for it. You take responsibility, he takes responsibility, and then we end the matter. We are saying that if he doesn't atone for it, then we reserve a right to issue contempt proceedings against the said authority. So we are making it very clear. He gives an apology, we end the matter there. If he does not, then we perpetuate the matter. We continue with the contempt. That's what we are saying.
Lordship.
And we have said wherever he is,
Lordship.
he'll just tender affidavit of apology, we end the matter there.
Lordship.
The registry shall not list the restore to file. That we don't have the record there. Okay, we'll restore it to file.
Well,
Yes,
grateful.
Lordship.
Make a mention for listing if it doesn't get listed in a week.
I'll do it. Very good, Sumar. Highly appreciated. Malad, the next review petition is also same, Malad. The petitioner is different. They are also relying on the same instruction, Malad. The writ petition was exposed.
Where this house is in which NH?
Same, Malad, 173. It's an adjacent land to this petitioner, Malad. Yes.
Okay, same order.
Same
Okay.
order. I'm highly grateful.
So
Yes, yes. Much obliged, Lordship.
we don't want to punish officers.
Yes,
My
Lordship.
daughter,
The
I understand.
intention is that the intention is that he must realize that what he has done is a mistake.
Yes, Lordship.
End of the
Malad,
matter.
I understand, Malad. It's a human,
I
Malad.
concede, Lordship.
Error can be by anyone.
And, with anyone. Say
Anyone.
sorry, we end.
Yes.
Otherwise, on record,